You are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
Local man ka dito, natanan sa silong.
All right. A beautiful and lovely morning to our MLGU participants. Before we start, may I request the Zoom participants to give us a quick thumbs up just to be certain that you can hear me loud and clear. All right, thank you. So to start our program, let us put ourselves to the holy presence of our Lord Jesus Christ. Loving Heavenly Father, we come to you this hour asking for your blessing and help as we gather together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with spirit of joy and enthusiasm. Give us the desire to find ways to excel in our work. Help us to work together and encourage each other to excellence. We ask that we would challenge each other to reach higher and farther to be the best we can be. We ask this in the name of our Lord Jesus Christ. Amen. Once again, thank God it's Friday and welcome to the 5th and last day of the online training for the municipal local government units on Republic Act 9184 and its 2016 revised implementing rules and regulations, brought to you by the Government Procurement Policy Board Technical Support Office. I am Marky Duetes of the Capacity Development Division, and I will be your host for today's virtual activity. Happy October 1st, guys! So we have now come to the last day of our training. So I hope, guys, na we still have this eagerness to participate to our discussion and to learn from our research speakers. So again, as promised, before we proceed to our program, we will be giving the special tokens again to our 2 early bird participants who has first entered the waiting room almost an hour before our program. Upon verification and validation of our technical team, we would like to announce our first early bird participants from LGU Cervantes, Miss Mary Alviar. Congratulations po. And our second early bird is from LGU Maragondon, Ms. Ana Risa Andaya. Congratulations po. Our event secretariat shall coordinate with you on how you may claim your special tokens. To our winners again, please make sure that you are registered to our OTMS because your prize will be forfeited once na hindi po kayo nakapag-register sa OTMS. Okay, so for today's activity, we're going to play word jumble. So ang mechanics lang po is you're going to guess kung ano po yung word na ito using the jumbled letters po na ipa-flash ko po sa screens ninyo. So all you have to do is to key in your answers po sa ating Zoom chat box. So are you ready na po ba kayo? Okay. So for our first jumbled letters, hulaan po natin to, paunahan po tayo. Okay. First jumbled letters. Okay. Yan. So ano po ang word na yan? Okay. Ang galing, may sumagot po agad ng tama. From LGU Cervantes din po ulit. Wow, ang LGU Cervantes active ah. So, the correct answer po ay procurement. So, tama, no? For our next jumbled letters or jumbled words, ayan po. Medyo madali lang po yung una, syempre. Ngayon, ulaan po natin yan. Okay, parang wala pong nagtatao. Okay, meron pong isa pa lang pong sumasagot. Ang tamang sagot po sa ating word number 2 ay remedy. So congratulations po from LGU Tagbilaran City for answering it correct. For our third jumbled letters po, ayan. Ano po ito? Okay. The correct answer is penal clause. So congratulations po, LGU Pagalungan, for getting it right. Next jumbled letters po. Ayan, medyo mahaba-haba po ito. Ito po ay Ops, kulang po. From LGU Santa Lucia, kulang po. Ayun. Ayun, meron ng tumama. So ang tamang sagot po natin sa word number 4 ay online blacklisting portal. For our last jumbled letters, ayan. Ano po ito? Wow. The correct word for this jumbled letters is appeal. All right, so napaka-active ni LGU Pagalungan. Sila ulit ang nauna. And that's it. I hope that all of us have picked a hint on what we're going to have for our discussion today. So again, we would like to remind again our Zoom participants to please register to the online training management system of the GPPBTSO by visiting the link and using the control number emailed to you by our event secretariat. Also, we would like to remind our participants to please accomplish the participants' daily attendance sheet through Google Form by visiting the link shared to you by our event secretariat in our Zoom chat box. Rest assured that all the information gathered for this online training shall be treated with utmost confidentiality consistent with the provision of the Data Privacy Act. Before we proceed, I will just give a quick recap for yesterday's learning session. So we have a meaningful and productive lecture with Mr. Absal Aba on the discussion about the various alternative methods of procurement and appropriate use of alternative methods of procurement based on the prescribed condition, procedure, and requirement. Okay, again, we would like to remind our participants to please keep your microphones on mute. Thank you. Moving on, before we dive to the program proper, let us give me an overview of the program of activities for the last day of our online training on government procurement. For today's activity, I am particularly excited because we will be tackling about the protest mechanisms and remedies and blacklisting guidelines. Further, to make our discussion even more exciting, as always, we are incorporating series of knowledge check wherein you're going to choose an answer to our Zoom polling feature. So we look forward for everyone to learn a lot from this online training again. So all right, let us now move on to the lecture proper for the first topic of this online training. With that, allow me to introduce our research speaker. Our research speaker graduated at the University of Southern Philippines Foundation with Bachelor of Laws, and she finished her master's in public policy at Tokyo. She is currently the Attorney 4 of the Legal Unit Office of the Regional Director of the Department of Interior and Local Government, Regional Office 7. Joining us today, the Attorney 4 of the Department of Interior and Local Government, Regional Office 7, and a GPPB recognized speaker. Please welcome Attorney Isa Fiel A. Nogra.
Hello.
Good morning po, attorney.
Good morning, everybody. Good morning. Hi. Can you hear me clearly? Kindly inform me if you cannot hear me clearly. Can you hear me clearly? Please. Okay, good. Thank you.
Yes po, ma'am.
Guess I
Loud and clear po, ma'am.
Okay. Sige. Kasi baka mamaya salita ko ng salita, wala na mime na pala. So anyway, we are on the last day, no? Parang naisip ko, I'm lucky because by this time you already have a faint idea, you already have at least an idea of what I'm gonna be talking about. I don't need to define a lot of terms already, but at the same time I feel sad because since I'm the last, you must have set your standards well already. I know my co-speakers, they're very good. They're trained by JPPB as well. And some of them are really working every day like you on procurements also. I'm more of a teacher, although I'm also part of the back, but I'm sure that the scale of my experience in the field would not be the same, no? Especially since I was away for a while. Anyway, whatever, since as a lawyer, I'm glad also I'm assigned with this topic because it involves a lot of legal remedies. So anyway, about protests, you must have heard already. While in your previous discussion, you talk about your lecturers talk about the things that you should do, the procedures. And my discussion, except for the protest proper and the blacklisting, I'm also gonna tell you what are the things that you should not do. Okay? So the things that you do, you already know that from the previous discussions. The thing you should not do, you will learn it from here. Yung mga bagay na dapat nyong iwasan. So I will speak both in English and Tagalog because apparently this is nationwide. But I've seen some of the participants are from Region 7, especially Tagbilaran. Hello to you. And I hope there will be a lot more Visayan LGUs who will join us also. So we will start our discussion with the first topic, that's the protest mechanism and remedies. Before, I remember there was a time that the blacklisting was just part of this topic, but it is good also that they separated this topic because it involves a lot of procedures and there can be it can be a long discussion, so it has to be separated as a module. So protest mechanism and remedies, we will start with the expectation settings. Those of you who have been trained by DILG, you know that we always start with the expectation setting. So for this discussion, for this module, we expect that the participants at the end of the discussion should be able to know the grounds, ano ang mga batayan, or remedies, ano ang mga pwedeng gawin sa offenses committed in relation to the, of course, the conduct and our participation in procurement activities. So yan yung first priority natin sa expectation setting. Malaman nyo what could be the grounds or remedies, not or, what could be the ground and remedies for offenses committed in relation to your conduct, anong ginagawa nyo, or your participation, kahit simple participation nyo, yung pakikisali lang. Kasi we know that in the Filipino mentality, we have this tendency na sunod-sunod lang what the seniors, those seniors were doing, iniisip natin, tama yan. Sunod lang tayo, follow lang tayo, pumirma sila, pirma din tayo. So, although hindi ka active, may passive ka lang, may ano pa rin yan, certain things that na accountable ka. So, a second natin sa expectation setting natin is after nyo malaman yung mga batayan at mga remedies, you will understand also what are the procedures and considerations in resolving requests for consideration and protest. Okay? Actually, may ano ako dyan kasi sa slides natin, I cannot change it. Ngayon ko lang napansin. Ang sinasabi pala is request for consideration and or protest. Sa atin kasi sa later in the discussion, you will notice it's really request for reconsideration and protest, not for and or protest. Kasi talagang dumadaan sa request for consideration. And of course, I will tell you later the rationale why it has to go through that phase first, not direct to the protest. Because of course, it's also part of the due process, not only on the part of the complainant, but also on the part of the government entity or employees involved with the back activities. So, dapat at the end of the activity, malaman natin na ano nga ba ang pwedeng grounds at ano ang pwedeng gawin. So, it involves everything. So, ang outline of our discussion would be the first, we will discuss the penal, civil, and administrative provisions. So, in penal, civil, and administrative provisions, dito natin i-emphasize yung threefold liability natin as government employees and officers involved in procurement, as well as yung mga private individuals and even public officers who are involved, who got themselves involved in these bidding procedures. So when we say private individuals, we are referring to your prospective bidders and suppliers. No? Sila yung iniisip natin na pwedeng ma-involve dito na maging liable. When it comes to public officers, please be reminded that it's not only those back members, back to our secretariat, TWG, and HOPE that can be liable. There can be other public officers who could also be liable once they get involved with the procurement, not only officially, directly, but behind the back. So yeah, kasama sila sa threefold liability. So the laws that will apply. Oh, good morning, everyone. Very unstable ang connection. Okay, sige. Hopefully, you'll have stable connection. So the laws that will apply for our first discussion would be RA 918 for the Government Procurement and Reform Act, which you discussed extensively. And of course, yung laging nandyan, mula pa sa, with or without this RA 9184, yung laging andyan, yung penal code, revised penal code natin sa bansa, at yung Code of Conduct, yung RA 6713. Siyempre, Code of Conduct of Government, Public Officials, and Employees. Saan ba yan? With or without the penal clause under RA 9184. So maraming tatamaan, no? May penal pa tayo, may administrative pa tayo, may civil pa tayo. So tatlo yan. Ang idea kasi ng threefold liability is one act could give rise to three liabilities. Isa lang nagawa ko, dami ko namang kaso. Oh, pasensya na, ganyan talaga yung batas. Duralex, sedlex, mahirap man, yan yung batas. So next natin din sa discussion would be RA 3019. If you're familiar with that, a lot of people are facing, a lot of government officials and employees are facing that case, lalo na pag nasa ombudsman yung case. Kasi marami siyang mga provisions doon na makaiwas ka man sa RA 6713 or sa revised penal code, tatamaan ka pa rin sa RA 3019. So, i-discuss din natin yan. Separate yan. Hindi pwede na, ay, nakasuhan na ako under RA 9184, hindi na ako makasuhan sa RA 3019. Ay, hindi. Ibang batas yan eh. Sa ibang liability. And then, we will go to, later also, we will go to the protest mechanisms. What are the requisites for filing of the request or motion for reconsideration and valid protest, no? So, paano siya hindi considered na unfiled? Ano yung mga timelines na dapat i-observe? Because we're gonna be very strict with timelines. Why? Because it involves procurement. And procurement, sabi nga, government project do not delay. Baka naman ma-delay lang sa kadaming mga dramahan, di ba? So there's timeline that we have to observe, and the private individuals who are dealing with us has to observe also. So, and of course, the last one would be blacklisting guidelines, which should be discussed separately. And then we will start now with the penal, civil, and administrative provisions. Klaro na po yung expectation settings natin. Pag di nyo po malaman yun at the end, pag hindi nyo po makuha yung mga grounds at remedies at di nyo po makuha yung procedure, it means po nagkulang ako. Emoji sticker. So yun, penal, civil, and administrative provisions. Start na po tayo. So, highest standard of ethics. Next slide po. Lagi kong naano yan. Sorry. So yan, highest standard of ethics. Ano nga ba yung standard of ethics natin? Kasi why is it demanded from us when it comes to government procurement? Kasi we will go back to the basic, no? Public office is a public trust. And it is exactly the reason why ang mga miyembro ng BAC, yung mga TWG, yung mga BACSEC natin, because of that kind of liability, we make sure that they are really part of our office. Hindi pwedeng kumuha tayo ng iba na hindi government officers. Kasi nga, baka may mga makumit sila, sana tinahabulin yan. O, diba? Or mahahabol man natin, hindi talaga the same level of accountability as we, government officials, na-attach sa atin. So yan, highest standard of ethics required to be observed by procuring entities, yung agencies natin, and bidders, manufacturers, suppliers, or distributors during the procurement and execution of contract. No? So yan yung i-observe natin because nga public office is a public trust. And we are unmute. Unmute. Kailan pa ako na-mute? Okay, sige. And not only because we are public officers na kailangan natin i-observe yung highest standard of ethics, but because we are dealing with public funds. It's not our money. If it's your money, you can do whatever you want. Kumain ka ngayon, bukas gutom ka. Uy, nalugi ka. Napabili ka kaagad sa Shopee. Tapos may mura pala sa Lazada. Diba? Okay lang yan. Ikaw lang nalulugi. Okay lang kahit wala kang procedure, kahit bumili ka, pumunta kang grocery na wala kang grocery list, okay lang yan. Ikaw lang din naman maghihirap, pera mo yan. But when it comes to the government money, it's a public money entrusted to us by the taxpayers. We have to be more circumspect. So that's why there's a procedure established by law. And that is why we have to follow these procedures. No? So bidders shall be determined to be, ano nga ba yung standard of ethics? Sa atin, define na yon ng RA 6713, RA 9184, RA 301, and define na yon ano ba yung dapat nating proper acts natin, proper conduct. But the bidders, especially those individuals na hindi naman sila government officers, no? They could just hindi naman kami official ng gobyerno, hindi kami dapat No, bidders are determined to have court. Pwede sila makakommit din. And it is classified, all these offenses are classified into 4. Actually, sobrang dami, but pwede mo silang i-group into 4. And that is, next slide, collusive, corrupt, coercive, and fraudulent practice. So maraming offenses na ma-define, na ma-enumerate under RA 9184 and even RA 3019, na pwedeng ipasok dito sa 4 na categories ng practices na bawal. Na dapat, yun yung sinasabi ko nga, these are the things that you should not do. No? No. Ito yung dapat nyo tanan, these are the things that you should not do. So, what is collusive then? Kung sa Tagalog, ang tawag natin dyan is sabuatan. No? May sabuatan, may arrangement sila. So, it is very anti-competitive. So, nalaman naman natin during previous discussion, competition is an important principle in procurement. Why? Because it allows the government to get value for money in their procurement. Value for money. The more may competition, the more natin na-expect na makukuha natin ang same item or quality for a lower price. So yun yung ini-expect. And sabihin man natin in actual, may ibang hindi naman all the time. But that is the natural expectation. That if there's competition, we will be able to take advantage, not to get the government will be able to take advantage of this competition to get a better quality for a lower price. So kaya yung collusive practice na yan, yung sabuatan, usapan, either with bidders among themselves, or yung tayo din, usually mga bidders among themselves, ikaw muna pare, akin ang next contract, daming ganito eh. Diba, daming contract, sige akin yan, next contract, akin naman. So yun yung titingnan natin na hindi mangyayari. So although we cannot know, we don't have eyes everywhere, but if these things are brought to our attention, it should raise an alarm, right? And there are remedies for that. Then next, another C. Kasi tatlong C, isang F yan eh. Are the corrupt practices, no? Sa Tagalog, sasabihin natin yan, pangangamkam, pagnanakaw, or unlawful enrichment. May nakuha ka, may nagain ka, no? May nagain ka out of a certain action na nagawa mo. So this one, the corrupt practices, pwedeng mangyari yan either sa back, sa membro ng back, kay Hope, sa mga backsec at PWG, and even public officers, kunyari lang ha, for example, syempre yung funds, lalo na may galing sa national or galing sa ibang or kaya perang galing sa mga international organizations, yung mga nag-broker dyan. Syempre, may iba din gustong makakuha ng share sa pie. So, yun yung titingnan natin na obserbahan natin na hindi natin magawa, no? Hindi natin dapat gawin. Yung unlawful enrichment talaga sasabihin mo, hindi ko naman sinadya, nahulog lang yung pera. Hindi ko naman, dumating yung pera o, hindi mo nga sinadya. But there is improper and unlawful enrichment of oneself or others or inducing others to do so by misusing your position. Nakuha mo dahil sa position mo or nakuha mo dahil sa opportunity na dumating dahil sa position mo. So, yun siya, no? Kasama dyan yung offering, bribing, giving, receiving, soliciting, no? Or anything of value. So, pupunta din tayo sa coercive. Later, makikita nyo, pasok-pasok nyo na lang sa utak nyo, saan kaya to papasok? As anong C to or sa F ba to? So, yung coercive practice naman, of course, to coerce, to threaten, pamimilit, or pananakot na kunyari, I will harm you, your wife, your kids. Those are considered as coercive practice. Or your son is working in my son's company also. I will fire them. I will, nagawan ko ng paraan yan para matanggal sa pwesto. Those are considered as coercive practices. Maraming coercive practice. It could be, minsan kasi, di ba, may tinatawag na wolf in sheep's clothing. Parang, hindi mo napapansin, tinatakot ka na pala. Di ba? Pabiro-biro lang. So you, as a back, it is not necessarily helpless if only you will, it's not necessarily helpless on this aspect, no? Kasi, pag sinabi mong helpless ka, bibigay ka, ay, may liability yan. Mas mahirap. Mahirap din, no? So, punta din tayo, may isa din na practice pa. Pwede natin i-classify later on yung mga offenses. Those are the fraudulent practices. So, yung fraudulent practice din, yung pagkukunwari, pagsisinungaling, pagpapanggap. So, just like coercive practice, it can be both an active and passive liability. Yung nagawa mo at di mo ginawa. Meron yun acts of commission or acts of omission. Yung ginawa mo, you commit something to fraudulently misrepresent some facts or yourself to influence the procurement process. Or pwedeng hindi mo ginawa, hindi mo sinabi. Kasi may mga ibang tao, sinasabi, hindi naman ako nagsisinungaling, di ko lang sinabi. Under the law, considered pa rin yun. Kasi acts of commission and omission ang kasama sa fraudulent practice. So, basically, yan yung grouping ng mga offenses na later i-enumerate. Marami kasi yan marami. So, you just have to keep on, trust your gut feel. If there is something wrong that you felt during procurement, parang isip niyo, parang pwede ba to o hindi? Just don't rely on others. Say, pwede yan, sa ginawa yan sa iba. Check your books. You have your RA 9184. Don't mind others when they say you are bookish, because this book could, opening and not opening this book could spell the difference between your time in jail or your security of tenure. So, ingat tayo, ha? Sabi maraming iba, ayaw ko naming mag-back. Very high yung accountability requirement. Sobrang taas ng requirement na. Pero, lalo na yung iba na ma-experience talaga na kasuhan. Yung iba naman gustong-gusto, takang-taka to, bakit gustong-gusto nila? Ang high kaya na accountability na tapos gusto, nagagalit pag di sila sinasali. Okay. Pero, isipin na lang natin na siguro because they are end users themselves and they want to make sure also na hindi mapabayaan yung mga needs ng offices nila. But hopefully that is the reason, no? Baka mamaya iba yung reason bakit atat na atat silang mag-back. Pero tayo, especially yung may mga experience talaga na nakasuhan, we know that mabigat siya. Kung didibdibin mo talaga, ano ba yung, kung isa sa puso, ayoko sabihin didibdibin kasi very negative yun, di ba? Parang sabihin nila, parang relax lang, chill lang, pero hindi naman, yung isa puso mo yung task mo, duties mo, mas alam mo na mabigat siya na responsibility. So next slide. So meron tayong knowledge check, no? These are random from the GPPB. They prepared this. So, hello po.
Hello po. So, all right. So,
Ang
we are
host-
now on our first knowledge check for our today's session. So, kindly choose your answer to our Zoom polling feature po. So, again, here's our question po. All are covered by penal revisions under RA 9184 except one. A. Misrepresentation. B. Collusion. C. Connivance. D. Malicious mischief. Again, all are covered by penal provision under RA 9184 except one. A. Misrepresentation. B. Collusion. C. Connivance. D. Malicious mischief.
Malicious mischief.
Yan, pa dyan.
All right, you can choose your answer po to our poll Zoom feature in 5, 4, 3, 2, and 1. All right, there we have it po, attorney. We have 81% po who answered letter D, malicious mischief, while there is 14% who answered misrepresentation and a 6% who answered collusion. Ano po ba ang tamang sagot po, ma'am?
Yeah, I think I can understand why some of the participants answered misrepresentation, because in the slides, it's more views as part of fraudulent acts, fraudulent practices, yung misrepresentation, no? But malicious mischief is the correct answer, because that one is covered under the revised penal code, no? Hindi, actually, it's a crime against public property. Hindi siya crimes against public officers nga. So the answer is malicious mischief, and 81% are correct. And 14%, I think it's because hindi ko na-clarify na, of course, yung fraudulent includes pagkukunwari, misrepresentation. Tinatagalog ko kasi kanina yung pagkukunwari. For collusion, maybe na-miss lang nila yung discussion, yung arrangement sa buhatan. So, connivance, okay, wala din. Yun lang. Malicious mischief.
All right, thank you po, attorney. We can now proceed po for this discussion.
Okay, so I discussed yung penal, civil, and administrative provisions. Sabihin ko lang because most of you are MLGUs, and now some of you have been in the service for longer than I am. Yung iba nga siguro di pa ako, high school pa lang ako, andyan na kayo sa serbisyo. Pero ito lang yung sasabihin ko, we're studying the ideal here, because we're not gonna teach you the not ideal. We're studying the ideal here to make sure na wala pong makukulong sa atin. Otherwise, wala na pong magbabak. So, yun lang kaya reason natin. We will stick with the ideals, and of course, you will have to deal with what's actual when you are in the actual setting. So, now let's start with the penal provisions. When we say penal, yun po yung mga criminal. That's another term for criminal. Penal provisions or the criminal provisions, it's the clause na nakakakulong. So, yun po yung kaso yun. Yung pag may criminal, kasi minsan pag sa ombudsman, meron pa kayong administrative case. Pagkatapos ng administrative case, ipo-forward yan sa DOJ, sa Prosecutor's Office for filing of criminal case. So, ito po, yung final criminal case po, dito po yan sa penal clause natin. So, RA 9184 has its own penal clause, no? Penal provisions separate from the penal provisions of Republic Act number 3019 or yung Anti-Graft and Corrupt Practices Act, and separate also from the provisions of revised penal code, yung crimes committed by public officers, yung mga bribery, direct bribery, falsification, mga ganun na So, separate to may sariling penal clause yung RA 9184. So, is covered by this Next slide po. Who is covered by the penal provisions under RA 9184? So, both public officers and private individuals are covered as so long as they commit any of the acts enumerated under the law and its IRR. No? So, individuals, yung sino-sino yung mga individuals na nakikisali sa atin. Yan yung mga private individuals, yung mga bidders, manufacturers, suppliers, sila yun eh. So, who are the public officers who commit any of the acts enumerated under the law? Tayo. Tayo yan. Pati yung mga ibang bossing sa kahit ibang opisina na nakikisali. So, for example, example ko lang ha, National Government Agency. Kunyari, ang procurement nasa DNR. Pero later, yung isa, kasi infra project kaya sa DNR, tapos, siyempre, si DPWH, marami siyang kilalang contractor, di ba? So, nakikisali, uy, yung kaibigan ko, may ano yan dyan. Oh. May maganda yung project yan dito sa amin. Sige, ano mo na lang, ganon. So, kahit hindi siya same agency, but he is a public officer, he will not be punished as a private individual, but rather for the penalties committed, penalties that will be imposed against public officers. Kasi nga, ginagamit na yung position niya or yung connection niya. Hindi naman siya magkakilala, di ba? Kung hindi dahil sa connection niya. Hindi siya ganun yung influence niya, hindi ganun na level kung wala yun, yung position niya. So, both public officers and private individuals na ma-involve sa procurement activities will be covered by the penal provisions of RA 9184. So, it also covers any, all types of procurement, whether done manually or electronically. So most sa atin talaga manual pa lang yung procurement natin. So some of the offenses that will be enumerated in the law refers too much about manual procurement. So makita mo anong bawal sa manual procurement. But there are also prohibited acts under electronic. So kahit electronic na yung procurement niya, covered pa rin siya sa penal clause dito pagpasok siya sa RA 9184. So any person, sino yung paano siya ma-cover ng sino ang covered nga uli? Yung mga private individuals at So kahit either manual or electronic yung procurement, kasama pa rin sa penal clause. So going back to the person previously na private individual na liable, it involves not only the person individual but pati yung company na where may controlling interest siya. For example, I'm the owner of A and B Corporation, and A and B Corporation has a criminal liability, and also its directors, officers, and employees who actually commit. So nung later, may iba din akong negosyo. Kahit nasa kulungan ako, as director of A and B Corporation, pero may controlling interest ako sa C and D Corporation. Kahit yung C and D Corporation as a juridical person, kasi meron tayong dalawang person, natural at juridical. So myself, as a natural person, yung liability ko, dahil sa involvement ko sa A and B, which is a juridical person, nakakari ko yan sa next corporation na may controlling interest ako. So, hindi pwedeng sabihin mo, ay, sa ibang negosyo naman niya yun. Dati sole entrepreneur siya, ngayon, dati director siya ng ganitong corporation, ngayon sole entrepreneur siya, pwede na siya. Hindi. Nakakari yung liability. And same also with the person, both although meron tayong separate yung personality ng natural at juridical corporations, sole enterprise, partnerships, joint ventures, at separate din yung natural. Siyempre, yung sinilang ka ng mama mo, yun yung natural. Lumabas ka kahit cesarean man yan or natural birth, considered as natural person. So, yung personality nyo, kahit separate yan under the law, yung liabilities nyo are attached to each other. Attached yan. Lalo na pag corporations, kung may controlling interest ka, pag tao, officer, employee ka, who actually commit any of the acts na prohibited. So, yun yung mga covered. Now, let's go to the penalties. So, what if I'm covered? What can be expected once the law find me liable. So, always remember this. This one will come out even in RA 3019. Yung Anti-Graft and Corrupt Practices Act is the 6115. And what is the relevance of that 115? No? So, it's imprisonment. Especially when it comes to penal provisions, pag ang na-violate mo is penal provisions, automatic yan. Pag ma-found guilty ka, it's imprisonment. So, ang imprisonment, it's for not less than 6 years and 1 day. Yan yung minimum. Kasi meron kasi sa criminal law yung minimum at maximum, minimum hanggang maximum. So, yung minimum na pwede mo ko is not less than 6 years and 1 day. Hindi pwedeng 6 years lang ang i-penalty sa'yo. Dapat may 1 day yan. And what's the relevance of the 1 day? For those of you who have studied law, you will remember the law on probation, no? Pag 6 years and 1 day, pwede ka mag-qualify sa probation. 6 years, pag 6 years below, pwede ka mag-qualify sa probation. Pag may 1 day yan, di ka na magka-qualify sa probation. Hihimas rehas po talaga tayo. Kaya yun po iwasan natin. Hindi nakakaganda yung rehas, no? Hindi nakakapogi. So, 6 years and 1 day but not more than 50 years. So, temporary or perpetual, under RA 9184, it's temporary or perpetual disqualification from public office. Kung doon ka, kung ang kaso mo ay RA 9184 lang, it will be different with RA 3019. Mas grabe yung liabilities sa RA 3019 and mas broader siya. So, temporary, kasi itong sa RA 9184, napansin ko yung penal provisions niya, it's very specific act. Whereas in RA 3019, maraming catch-all. So, yun yung inatan din natin. And then, of course, other than the imprisonment, other than the disqualification from public office, also the permanent disqualification from transacting business with the government if you're a private individual. Ito, although nakalagay sa slides na yung disqualification is for public official or the disqualification for transacting business is private individual, always remember that, for example, if you're a private individual who was previously found to be liable criminally, administratively, or civilly, under RA 9184, RA 3019, once tatakbo ka sa pwesto, kung nangyari, naisip mo, hindi na ako makabid, mag-mayor na lang ako, vice mayor na ako, mag-governor na lang ako, pa-public office na lang ako. Yung disqualification po, kasama po yun sa inyo. Pag mag-decide kayo na mag-public officials kayo, meron din kayong disqualification. No? Pwede kayong ma-disqualified niyan. How about the public officials na natanggal sa pwesto? Magaling naman ako kasi kahit nakulong ako doon sa isang transaction or kahit natanggal ako, na-dismiss ako sa serbisyo dahil sa isang transaction, may experience ako sa procurement, sa magko-contractor na lang ako. Meron din po kayo permanent disqualification for transacting business with the government. Is it automatic? Diba? I mean, of course, when it comes to penal provisions, always remember that there has to be due process. It has to go through the court or dapat dumaan ka sa due process. Hindi yan automatic, we found you, ganyan pinagagawin. Hindi yan automatic. No, dapat nga, pati penalty nakalagay talaga sa decision before. Kasi minsan may mga decision, I've seen some decisions with focusing only on the principal penalty. Sometimes hindi nakalagay anong accessory penalty. No? So, of course, when it comes to criminal cases, you don't assume the penalties. Unlike sa admin kasi minsan kasama na yun, parang pinis sila. So sa criminal hindi pwedeng i-assume yung penalty. It must be stated there. And of course, other than that, so sabi mo may imprisonment, may disqualification from public office, and my permanent disqualification din sa transacting business. Also, there's confiscation and forfeiture in favor of the government of any prohibited interest and unexplained wealth manifestly out of proportion of your income. So, pwede po yung i-pray ng ombudsman or ng private prosecutor na ikasama na ang forfeiture. Kasi especially if, for example, during the administrative case, kulang na yung pag-forfeit ng mga ibang receivables na benefit mo, kulang na talaga sa dapat mong isoli sa gobyerno. So, doon na lang yan isasali sa criminal case na may mga penalties din na pwede. Kunyari, kasi when it comes to administrative case, hindi kasi pwedeng mag-attach yung mga, walang attachment, walang garnishment. Pero when it comes to criminal case, pwedeng gamitin ng court yung power to impose the penalty of garnishment and attachment para talaga masoli nyo ano yung unexplained, ano yung nakuha nyo sa gobyerno, yung unexplained portion of your wealth. No? Wealth, kasi minsan sabi natin, oh, may nakamkam siya, wala na siyang pera, saan yung nakamkam niya? Siyempre, marami siyang pinapaaral. May mga scholars siya galing sa asawa niya, tapos naghanap pa siya ng ibang scholar galing sa, di ba? So sobrang dami, kahit may nanakaw, kahit may unwarranted benefit siya, hindi madaling bawiin yung nakuha niya sa gobyerno kasi nga marami siyang binubuhay. So doon papasok yung sa forfeiture not only of his benefits, but in criminal procedure, it also can be, attachment and garnishment can also be used, no, para sa forfeiture. So then jurisdiction over offenses defined under this rule shall belong to the appropriate courts according to laws existing at the time of the commission of the offense. So usually kasi ombudsman talaga pinafile or ang mga ganito. Kasi nga minsan din sandigan bayan, it depends on the salary grade. So pag may isang, kasi nga hindi naman hiwa-hiwalay kayong itatry, di ba? Pag may isa sa inyo talaga napasok sa sandigan bayan, kayo na lahat yan. Doon na kayo sa sandigan bayan. Kasi hindi naman pwedeng separate, yung iba na sa ombudsman, yung iba na sa sandigan bayan. So doon na kayo ay itatry niyan. Of course, may mga appeals proceedings pa din. And also, later sa inyo na part, makikita nyo, meron tayo kasing compensation niya, parang fund yan. So later, i-ano ko na lang. So yan, jurisdiction of offenses under this rule, usually sandigan bayan, on RTC also. RTC can also handle especially the criminal aspect, no? Because in an administrative case, the ombudsman will both be the prosecutor and the judge. Parang siya din ang magde-decide. I-approve lang yan sa higher authority nila. But when it comes to criminal cases, the ombudsman will act now as the public prosecutor para pa-file yan sa regular courts. So, punta tayo sa next slide. So, ano nga ba yung mga offenses na yun? Again, I will mention how it was categorized, yung practices: collusive, coercive, corrupt, and fraudulent. Okay, right now I will read to you, I will enumerate to you some of these offenses that can be committed, and ipapasok natin yan. Saan siya pasok? Collusive, coercive, okay. So we'll start with nasa section 65 yan ng RA 9184, and it doesn't, I don't think it didn't change kasi most sa mga na-change sa RA 9184 are the procedures, not this part. So opening of sealed bids, including but not limited to bids that may have been submitted through the electronic system. So saan siya? Bakit mo bubuksan? The question is, bakit mo bubuksan? May interest ka ba? No? Kung sino, magkano yung bid sa iba. Kasi although most of the time, the bidders will just submit it, di ba? Yung on the day ng submission of bids natin, at the same time opening of bids, usually same na lang. Kasi nga lahat naman ng procurement natin, madalian, di ba? So, say, pag gano'n na situation, kahit pag mabuksan yan, hindi din naman change, no? But of course, it's still bawal. Why? Because it will just open. Kasi pag nakita nyo yung bid, not only will it give you an opportunity to tip, not only will it give a corrupt mind the opportunity to give the other bidders an advantage, like a tip perhaps, it will also influence your thinking, yung judgment nyo. Kasi diba sa opening of bids, ang tinitingnan natin na criteria talaga sa preliminary examination of bids, yung sa eligibility requirement, is pass-fail. Diba? Meron tayong pass-fail. Pag nakita nyo na magkano yung bid niya, ang tendency kasi nakita nyo, sayang mababa yun, ipilit nyo. Nai-influence kasi kayo, nasasayangan kayo eh. Oh, so para hindi kayo ma-influence, walang advance na opening. No? Especially sa envelope 2. Kahit ano pa, wala talaga, hindi mo uunahan yan. Bawal yan. So, bakit? Kasi may expectation, hindi naman expectation, umiiwas, ang law, iniiwas kayo na maging corrupt. Kasi nga, nakukorrupt kayo kasi na-influensyahan na yung utak nyo. No? So, Next would be delaying without justifiable cause, the screening for procurement process. Although this is how it is worded, ang inaano natin yan, the screening for eligibility, opening of bids, evaluation and post-evaluation of bids, and awarding of contracts beyond the prescribed periods of action. So under the law, we have periods of action kung ano yung minimum at maximum time para sa each phase, no? So pag ma-delay yan without justifiable cause, that can be also a ground for that could also make you liable. So inassume pa rin yan. Grabe no? Saan siya pasok? Hindi naman siya automatic na corrupt. Pero iniiwas kayo sa possible corrupt activities na mangyayari in between those delays. Yun yung iniiwas sa inyo ng batas. Okay? So, wala namang collusive na nangyayari. Wala namang coercion nangyayari. Wala namang fraudulence na nangyayari. But, there could be behind the scene an opportunity to do corrupt activities. So, yun yung iniiwas sa atin. So, it must be with justifiable cause. Kunyari, ngayon yung opening of bids, a submission at opening of bids nyo, bigla, may malakas na lindol. Natural. Ano kayo, hero? Of course, the law also understand certain circumstances, especially unforeseeable one. No? Especially now, COVID, marami din tayong na-encounter na problem niyan. I hope wala pa sa inyo yung back na nabawasan because of COVID. Napapaano ako, no? Kasi mahirap din, no? Mga kasama natin sa office. So, yun lang siguro. And, yeah, without justifiable cause ang titingnan. If duly justified, may resolution kayo dyan dapat. Para at least lahat ng agreements, lahat ng reasons on paper. Then, another would be unduly influencing or exerting undue pressure on any member of the back or any officer of the procuring entity. Ito, pasok to sa coercive, no? So, sino ang binibigyan ng pressure? Any member of the back or any officer of the procuring entity. Sino ang nag-influence at nag-exert ng undue and pressure? It could be anybody. No? Not only your direct, not only your prospective suppliers, manufacturers, or sponsors, etc. But it could also be private individuals who are powerful, mga tycoon. Or it could be other public officers, ibang agencies who has, some friendship or some baka may sex video siya. So, pwede niyang i-threaten. Or baka magjowa yung anak nila, pwede niyang i-threaten. So, ganun. Maraming ganun. So, pasok yan sa coercive. So, another is the splitting of contracts. Maraming dito. Ano nga ba yung splitting? Of course, it was defined already to you. But, ito lang ko dyan. Whenever someone asks me that, could it be considered splitting, ma'am, or attorney, or not? Ito lang sasabihin ko, pag yung funds sa kabuuan ng project, available na siya, wala na kayong hinihintay, and all phases can be executed already at once, may bigay na siya ng isang contract, hindi mo na yan pwedeng split na hiwa-hiwalayin pa, may phase ka pa. Okay ang phase, at lot, if justified siya sa nature ng contract, nature ng project. For example, of course, alam naman natin, di ba, ilalat natin yung iba kasi alam natin walang supplier na maka-provide niyan. Kung i-expect natin na isang supplier lang ang maka-win ng contract na yan, pwede yan, lahat. Sa phase din, kunyari, sa mga buildings, may iba naman talaga specialty nila ganito. Hindi naman lahat ng contractor may access siya lahat agad sa materials, or di ba? Meron iba, may sa lupa pa sila, may sa ano pa, iba-iba yung contractor mo. Okay yan. Hindi yan splitting of contracts. Pero, ano lang siya na, yun lang titingnan nyo talaga. Minsan din, like kami, honestly, meron din kami time na, kahit sa office namin, kasi hindi dumadating buo yung project, yung fund. Tapos gusto nila ipaprocure na. So, inuuna na namin. So, ang next na yan na yung batch 2. Ibang procurement na naman yun. No? Kasi kung hihintayin mo pa, mag-expire na yung fund. Kasi may mga expiration din yung ibang fund eh. So, yun yung tinitingnan din namin. So, yun lang ang batayan nyo. Kasi kung pwede nyo nag-i-implement at that time, pwede na one time, ano pa, bakit mo pa i-split? Diba? Pwede namang isang contractor magawa yan. Ha? Baka naman mamaya, iba yung poste, iba yung wall. Okay lang yung iba yung roof kasi may iba talaga, iba yung roofing, iba yung mga sa lupa. So, pwede yun. Pero, wag naman yung, ma'am, may nakita ako, actual project to. Ano yung nangyari sa market nyo? Bakit parang puro palang poste? Tagal na niya. Phase 1 pa yan, ma'am, poste. Sabi ko, bakit kayo nagsa-start ng project na poste lang pala kaya nyong i-afford? Di sana hindi kasi di ba, parang, so saan yung phase 2? Naghihintay pa kami, ma'am, ng fund, ma'am. Ano yung phase 2 nyo? Wala. Sabi ko, my God, parang poor planning siya talaga. And in the end, it all goes back to the procurement planning, no? So, yun din. So, when the head of the maraming bibiktima dyan sa splitting because of poor planning. So, you have to make sure that your end users are responsible no, in preparing. Kasi kung itong end users, minsan, hindi naman lahat ng end user kasama sa back. So, minsan, kung ano-ano lang so bantayan nyo yung end users nyo, especially during pre-procurement process. So, when the head of the agency abuses the exercise of his power to reject any and all bids, no? Why? Because it could be a ground for corruption. Although, di ba, naalala niyo yung Article 41, the reservation clause, when there are instances which could lead the hope, no? Dali, tingnan, basahan ko to ha. When there are, the head of the procurement reserves the right to reject any and all bids, declare a failure of bidding. Pwede siya mag-declare na failure of bidding if there's a prima facie evidence of collusion, no, if the back is found to have failed to follow the prescribed bidding procedure or for any justifiable and reasonable grounds, pwede niyang exercise yung reservation clause niya to reject any and all bids. Yun si Hope. But, it cannot be abused. Baka naman reject lang siya reject kasi hindi yung friend niya yung lowest bidder lagi. Hindi lagi yung lowest. Kasi pumasa yung lowest, yung sa friend niya, second lowest pala, hindi nakuha yung contract. Or hindi talaga, or kahit second lowest bidder pa yung friend niya, hindi pumasa sa post-qua. So, hindi pwedeng ma-abuse yung reservation clause kasi there is a possibility that it could be used for corrupt reasons. So, yan, Pwede kasi na corrupt yung, may bahid ng corruption. Kasi tinitingnan dyan yung sniff of corruption. Di ba? May bahid ng corruption. Naalala ko tuloy yung sniff. So, yun. Tingnan niya na, yan din isa sa mga bawal. Kasi it could be abused. Then also, yan, yung sa mga crimes yan ng public officers. Tayo as a back, dito tayo nasasali. Ino-open natin, dinidelay natin, may nag-influence siya may ino-influence natin yung iba, may pressure, ni-split natin yung contract, tapos reject tayo ng reject. Of course, by private individuals, meron din silang penal provisions for them, no? Specific sa kanila. And common to, kahit hindi sila umaamin, kahit ayaw nyo, alam natin, there are things happening behind their back. Kasi ako din, nakaka-lecture din ako dati sa PIC. And I've heard stories, yung sa Philippine Institute of Civil Engineers. I've heard stories also, and nakakatawa lang, kasi ako at that time, di pa nila alam, ako yung speaker nila. Kasi I was a lot younger back then. So, kwento ng kwento regarding ang iba, kilala ko, syempre, DILG ako kilala ko yung ibang mga mayor, kilala ko yung ibang mga nakaka-train din ako sa local government code kasi sa iba sa mga local government functionaries. So, wala lang, pangiti-ngiti lang ako. So, yun, yung makikita mo. Ito yung mga agreement and submission. Kasi pinag-usapan nila yung mga upcoming na mga projects. So, yan. Agreement and submission to submit bids with pre-arranged lowest bid. Pare, may dalawang barangay roads na ipibid yung ganitong municipality. Sige, kasi minsan 'di ba pag malayo yung municipality, we have to admit kasi may mga projects din kami dati na mga roads pag malayo kasi yung LGUs, kukonti lang din yung interesado na mga bidders kasi nga they have to bring forth pa the equipments, no? And hindi madali kasi nga some of them, for example, I'm the contractor, I have projects here in the city and yung equipments ko, palipat-lipat lang yan from one project site to another. Tapos yung iba, sobrang layo. Kukross pa ako ng island. Especially in Region 7, this is very common kasi island po kasi kami, hiwa-hiwalay yung mga provinces namin. So, that's why some of the LGUs cannot get proper, so yun lang, minsan yung ibang mga contractors, parang suki na lang. Suki-suki. Kasi nga, pati yung LGU nadi-dispute na, huy, mag-bid kayo sa amin kasi ayaw namin mag-failure of bidding, di ba? Nakakaanpagod din yung lagi failure of bidding eh. We should know, right? So, nag-ano na sila, sige, sa iyo yan, sa akin to. Pero, kunyari, nagbibid sila. Kaya, para sabihin din may competition. Kasi baka, minsan maki-question na, bakit sila lang nang sila yung nag-grant na bibigyan, na-awardan ng contract? Paulit-ulit yung na-awardan ng contract. Tapos walang, laging sole bidder lang. So, minsan naman, lagyan natin ng competition kunyari. Pero, ikaw ngayon, ako ito sa isa, ganon. So, meron dyan, hindi ko na sasabihin yung iba kasi alam naman natin maraming mga pinagagawa, no? Minsan kasi I have to stop myself from saying kasi alam nyo na yun eh. Nakikita nyo yun. Then again, another would be agreement, malicious submission of different bids through 2 or more persons. I can't really understand what's the rationale for them. Siguro gusto nila sila yung, di ba, kasi they can only if they will submit one bid, it's like they're putting their chances, parang coin toss coin, baka mamaya may ibang mas lower sa'yo. Siguro naisip nila more chances of winning, di ba? The more bids, more chances of winning. Parang parang loto lang. No? The more tayo maraming kusta, baka maraming chances tayo manalo. So, iba-iba yung bid niya. Dalawa, tatlong bid niya, iba-iba yung price. Grabe naman kung may isa pang, kung hindi pa manalo, hindi pa makuha yung award, hindi pa ma-award sa kanila, di ba? So, yun yung inaano nila. So, kasi i-withdraw lang nila pag, mababa pala, wala pala tayong competition, ito na, withdraw na lang yan. So, another would be employment of scheme disadvantages to the public, and ito, agreement to secure undue advantage. So, yung mga usapan talaga to, lahat scheme. These are all pasok sa collusion, no? Collusion to na collusive practices. Then, another also with the private individuals. Dali naghang yung presentation ko. Okay. By private individuals also, when 2 or more bidders agree, come to agreement which call upon one to refrain from, next slide po, from bidding for procurement contracts or which will call for withdrawal of bids. No? Parang may usapan sila, kunyari, akin lang yung contract pare, pero baka pwedeng mag-withdraw ka. Kasi siya pala yung naging lowest. Tapos interesado ka sa contract na yan. Tapos sasabihin na lang ng contractor, sige, hindi na ako magbibid dun sa isang project, sa'yo na lang yun. Kasi I'm interested with this. Ganun. Kasama din yan sa mga, medyo malito kasi may nakalagay dyan na administrative sanctions. Actually, those are still offenses committed. So, I'm calling for GPPB, correct lang to. Hindi pa to administrative sanctions. So, when a bidder maliciously submits different bids to 2 or more persons, corporations, when a bidder by himself or connivance with others employ schemes which tend to restrain the natural rivalry of the parties. Ito talaga, yung mga collusive na practices, it's because we have this principle for competition and also transparency, no? Na hindi tayo hindi mabibiktima yung gobyerno sa ganong mga arrangement. Kasi nga, mako-compromise yung chances ng gobyerno to get value for money sa nila. So, again, also ito, mga withdrawal of bids, using name of another. Dati may mga cases na ganito. And you should be careful. Di ba may pass-fail criteria tayo? Sa pick-up kasi nila, minsan, hindi lalo na kasi ngayon nationwide na tayo, di ba? Hindi na tayo sa specific geographical location lang tayo pwedeng mag-bid. So marami nagbibid sa inyo na minsan hindi nyo kilala, di ba? Minsan nasa Hulo, nasa Batanes, tapos nagbibid sa Iloilo, nagbibid sa Samar, or nagbibid sa Bohol. So, hindi nyo kilala tong mga to. Hindi nyo, kala niya, iisipin na hindi lang kami mabe-verify, kami ba talaga to? Kasi hindi naman talaga yung may-ari yung pumupunta dyan. Usually, may authorized representative lang sila. So, ang question, ilan ba yung ino-authorized representative ng may-anang nakapangalan sa PICAP? So, titingnan natin, dapat isa yan sa pwedeng tingnan. Although, sa preliminary examination, on the surface lang kayo mag-i-examine, during mga post-qua, pwede nyo namang i-check yan with other government agencies na meron silang previous contract. No? Pwede silang i-check yan. Ito, false information or falsified documents. So, not only you will be penalized under RA 9184 and RA 3019 for false information or falsified documents, remember that the your OSS omnibus sworn statement is actually notarized, di ba? So, may perjury yan kasama. Pwede din kayong ma-falsification, no? Sa mga ganyan. So, may revised penal code liability yan. So, let's go to the knowledge check. Ito. Knowledge check na po tayo.
Okay. Medyo naghang lang po siguro ang ating
Oo, naghang kanina.
Ayan. So yan. We're now on our second knowledge check po for this session. So the question is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? A, yes. B, no. Must first be proven to be without justifiable cause. Again, is non-submission or delay in submission of documents for the final awarding of contract considered automatically as withdrawal of bid? A, yes. B, no. Must first be proven to be without justifiable cause. Again, please select your answer to our Zoom polling feature po, mga participants. Alright, so I guess marami po ang sumasagot ng letter B na no, must first be proven to be without justifiable cause. Again, please select po your answer in 5, 4, 3, 2, and 1. There we have it po, attorney. 89 or bumaba. 87% po ang sumagot ng letter B. No must first be proven to be without justifiable cause, while we have naman pong 13% of our participants who answered yes. So attorney, ano po ba ang tamang sagot po para sa tanong ito?
Actually, that's correct. No, it must first be proven to be without justifiable cause. I was surprised actually, no, because in my discussion, I never mentioned about that. I think the one that I mentioned na without with justifiable cause, with or without, is yung sa delay in the opening of bids. But when it comes to withdrawal, hindi ko na mention actually na it must be proven to be without justifiable cause. But I guess the participants, of course, they're very experience, and also their common sense is very expected to be high. So nakita naman nila na kasi yung withdrawal of bid, nung na-mention ko yung withdrawal of bid, it's only for purposes of collusion. So, yung na-mention ko yung withdrawal of bid na pwedeng liable sila kasi nga ginagamit for collusion purposes. O, mag-bid ako tapos hindi pala ako yung lowest o atrasan, withdraw ka para ako yung lowest. So, yun yung without justifiable cause. So, meaning, if may justifiable cause, hindi siya automatic na considered as automatically withdrawal of bid, yung non-submission or delay in the submission of documents, no? So it must, so I like it na kahit hindi ko masyadong na-discuss, they for themselves were able to guess it from the discussion about yung aspect ng liability. Hindi automatic na may mga ganitong kakulangan, automatic liable ka. Dapat meron ding cause. May pasok siya sa reason bakit liable dapat. So I'm glad that they were able to answer it. Yes, letter B.
All right, thank you po. No? So our participants, just keep our research speaker impressed po sa ating mga knowledge check. So again, attorney, let's continue po our discussion.
Okay. So next would be civil liability. So kanina pinag-usapan natin yung mga penal liabilities under RA 9184 na pwedeng ikakakulong ng public officer at private individuals involved. Now, we will go to the civil liability. Usually, di ba, na-mention ko, three-folds liability yung one act to give rise to three liabilities under the law, no? It's civil, criminal, and administrative. The civil liability talks about other than ma-dismiss ka sa posisyon mo, other than na pwede kang makulong at ma-disqualify, ano pang pwedeng makuha sa'yo? So usually it calls for damages. Ito yung tinatawag na hindi ka pwedeng thank you lang. Mayaman ako, kahit makulong ako, okay lang yung pamilya ko, kahit matanggal ako sa serbisyo ko, okay lang yung pamilya ko, hindi. Kasi meron po tayong mga damages. Yung damage kasi is the damage that it is something that you owe to the government, you owe to the people for the damage done for your certain action. So yung civil liability for any violation of RA 9184 could be restitution. Isusoli mo kung anong nakuha mo. Restitution or forfeiture in favor government of any unwarranted benefit derived from the acts in question or both at the discretion of the court. So this is without prejudice to the administrative sanctions that may be imposed in proper cases. So separate pa yan. A conviction, usually kasi itong restitution for damage done or forfeiture in favor of the government, it is usually part of the accessory penalty in the criminal case. Doon siya isasali. Kasi sa administrative case kasi, for example, yung ombudsman kasi, they can sa administrative, sa civil service, they can also, even us, yung mga regional offices kami pwede din. Pero wala kaming power to demand restitution kasi yung damages sa courts lang yan, just like the imprisonment. So what's the difference in forfeiture in favor of the government and restitution for the damage done? Ito lang sabihin ko. Forfeiture in favor of the government is yung ano yung nakuha mo. Kunyari may bribe ka na natanggap na 2 million at tapos nalugi ang government ng kunyari 1 million dahil sa discrepancy sa price, sobrang pinalobo yung ABC, yun yung isusoli mo. Forfeiture of unwarranted benefit na nakuha mo at yun yung nakuha mo is 2 million. 2 million ba yung bribe na sabi ko? Sorry. So yung bribe na mo, yun yung ipo-forfeit. Kasi yun yung unwarranted benefit mo. Then, how about the 1 million? That is restitution for the damage done. Yan yung isusoli mo kasi nalugi ang gobyerno ng 1 million dahil sa acts mo. Not only that, restitution for the damage done, there are also other damages that can be included. Those are actual damage yung 1 million mo. Pero meron pa kasi exemplary damage niyan. No? May exemplary damages pa kasi yan. Isa-sample ka. Yung exemplary damages, yun yung damage na i-impose ng courts against you to serve as an example to others. Yes. Kaya minsan dun lolobo yung damages na i-restitute mo. So yun yung forfeiture, ano ang nakuha mo? Restitution, yan yung nakawala sa gobyerno. At ano pa ang pwedeng damages other damages na ipipray, prayers for relief ng ombudsman na igagrant ng court. So yun yung mga civil liabilities nyo. Actually, when you talk about civil liabilities, it's more of pera-pera yan. Ano yung kukunin sa'yo. So sabi, wala naman ako pera, wala sa makukuha. Remember, merong, when it's not only cash, no? It's not only cash. It includes all other benefits and even properties. Kasi pwedeng i-garnish, i-attach yun. Yung mga corporations, pwedeng i-attach yung mga assets nila. Yung mga, especially mga sole entrepreneurs, yung mga tindahan nila, yung mga stocks nila. Tayo din, so nasa gobyerno, meron din tayong mga receivables from GSIS, yung mga contribution natin. Pwede yung i-garnish. So, yun yung pwedeng pagkunan ng civil liability na i-grant ng court. Now, let's go to administrative sanctions. Tapos na tayo sa idea na pwede pala tayong makulong as main penalty, as accessory penalty, meron pa tayong disqualification to run public office, meron pa tayong disqualification to transact with the government, meron pa tayong forfeiture na wala yung kinuha na gain na benefit natin, na wala din yung tapos pinabayad pa tayo sa nalugi sa gobyerno, meron din po tayong administrative sanction. Okay, so administrative sanction, always remember suspension and blacklisting. They are not the same. Okay, when you say suspension, of course, it refers to the government agency, the procuring entity. No? Pag sinasabi naman na blacklisting, it could involve others already. So, itong blacklisting, mahirap to for the businesses, no? Yung mga suppliers manufacturers natin, mahirap pag na blacklist sila kasi it could mean a great reduction of their possible profits from other activities with other procuring entities, other government agencies. So, let's go with the suspension. So, of course, my first strike, second strike yan. Pag first offense na 1 year lang, no? Suspension for 1 year for first offense and for 2 years for second offense for the suppliers or prospective bidders in participating in public bidding process, no? And disqualification from further participating in the public bidding being undertaken by the procuring entity. So now, this is in addition to the penal and civil sanction. So, pag may nakita kayong offenses, kahit hindi pa yan kahit hindi pa muna i-litigate yung civil at criminal aspect, the ombudsman or even the HOPE, subject to the authority of the BAC, pag may na-found sila na grounds, could impose this on the bidders or prospective bidders. The penalty of suspension for 1 year or the penalty of suspension for 2 years. If second time na niya, kasi nga, di ba, fool me once, shame on me, fool me twice, shame on you. Ay, bali pala. Fool me once, shame on you. Fool me twice, shame on me. So, yun yung pwedeng a penalty sa administrative sanction sa prospective bidders, suppliers, and manufacturers. Hindi sila makakasali sa bidding. Hindi nila pwedeng tapusin yan, yung procuring entity, hindi na sa pwedeng mag-continue sa procurement activity na yan, in particular, at hindi na din sa pwedeng sumali sa next. Now, let's go to the others also. Disqualification from ito, kasama na yan. Pwede din silang ma-forfeit yung bid security nila. If ang grounds for suspension, it refers to those grounds na during bidding process, no? But if later pa, like for example, during contract implementation na sa kanila found out ng HOPE or ng anybody, for example, later na examine uli ng observer na matinik, kunyari matinik na observer, lagi naghanap ng butas ng gobyerno, or yung kaya kalaban ni HOPE, especially if si HOPE, isang politiko, mayor, kalaban ni HOPE yan, naghanap ng butas. So, later nakita na ongoing na ang project, meron ng contract, pero nakita na may discrepancy or may mali during bidding procedures. So, since tapos na yung bid, na-expire na yung bid security at performance security na ang andyan, yung performance security po ang ipo-forfeit. Hindi pwedeng, wala na siyang bid security, hindi naman yung performance security for performance naman yan. Hindi, it's still a security. So, pwedeng doon kunin. Then, of course, blacklisting, no? So, yan yung blacklisting. It's a separate topic, but it's still related here. So, next slide. So, punta naman tayo sa liabilities under RA 3019. Can we have a restroom break for a minute or two? Tapos na tayo sa RA 9184, yung offenses at yung penalties. We will proceed with RA 3019 or the Anti-Graft and Corrupt Practices Act. But first, can I leave the screen for a restroom break? Hello? Hello? Hala. Hala, naghang? Hello?
Yes, ma'am.
Yes,
Okay,
yes.
ma'am.
Okay, sige. Hello. So I'm back. Ah, mahirap din tong on Zoom, no? Kasi like me, I really like sana talaga yung may makakatch ako na parang may kausap ako. Yun yung essence, yun yung talaga nakaka-inspire makipag-usap, tapos nakita mo may certain understanding yung mata. Tapos sabi ko, since Zoom na lang to, kausapin ko na lang sarili ko. Gusto ko makita sarili ko sa screen para at least parang kinakausap ko sarili ko. Hindi ako nagmo-monologue dito, no? Pero may problem pa rin, hindi ko nga makita sarili ko. So kausap ko talaga ngayon laptop tsaka pitchel ng tubig sa harap ko. So if I hope it's still as effective. So, now let's proceed with liabilities under RA 3019. Kasi nga, one act, not only triples liability, iba-iba pang mga law ang tatamaan ng act mo. So, let's go to Anti-Graft and Corrupt Practices Act. This one, ito yung hindi lang ang hope ang pwedeng take over ng jurisdiction, or hindi lang yung courts, but even also ito talaga yung most sa cases filed under the ombudsman. And I was talking before, just recently, with one of the ombudsman investigator. Sabi nga, most talaga sa mga kaso na involve yung local government officials, involve back yung procurement activities. Kasi nga, doon talaga ang maraming movement ng government transactions and money, no? So yun yung karamihan sa kaso nila when it involves local government officials. Usually bidding procurement talaga. So I'm quite sad about that because ako LG ako eh. Parang saan kami nagkulang? Anyway. So liabilities under RA 3019, marami siya but mostly it's enumerated in section 3. So persuade ito yung nakaka-difference, ito yung different with the RA 9184. Kasi RA 3019 will find you liable if you persuade, induce, or influence another public officer to perform an act constituting a violation of rules and regulations, and at the same time, if you allow yourself to be persuaded, induced, or influenced to commit such violation or offense. Bakit ganun, di ba? Parang, tinatakot kami. Kasi po, like it or not, there's di ba, requirement, isa kasi sa qualifications natin to be a back member is our integrity. Na meron tayong integrity as a public officer. Ngayon, if madali pala tayong takutin, madali pala tayong ma-impluwensyahan, madali pala tayong magoyo, then asan yung integrity natin? Yun yung concept na, yun yung idea ng law. Bakit pinapunish pati yung nagpa-persuade ka, nagpa-induce ka, or nagpa-influence ka to commit such violence or offense. You will only be not liable until such time you say yes. Okay? Because it emphasizes the principle that members of the back should not in any way allow themselves to be pressured or influenced in any way, and that they should their functions based on the mandates of the law and the dictates of their good conscience. Kaya, like for example, if may mga pinagagawa ka sa likod na pwedeng maging bala against you, it's a question of your integrity. Kasi the enemies of the government, and you as the agent of the government should not have a bullet against you na pwede nilang magamit later in the future. Okay lang sabihin nila na pangit tayo, amoy bawang tayo. Huwag lang sabihin, alam ko pinagagawa mo, may ano ka, ganyan. Tapos natakot ka na. And it includes your family even, no? Na kaya tayo, we act accordingly as public officers. Kasi under RA 3019 kasi, it is not specifically passed for purposes lang sa RA 9184. Kasi may separate nga penal provisions RA 9184. RA 3019 is applicable lahat talaga yan sa pinagagawa natin sa gobyerno. So, since kunyari, public officers, kasi nga, public office sa public trust tayo, dapat walang makita yung iba na reason na mag-submit tayo sa persuasion or influence na nangyayari. Strong character nga, kunyari. So, Another would be directly or indirectly requesting or receiving any gifts. Next, present, next line, share, percentage, or benefit for himself or for any other person in connection with any government or transaction, with any contract or transaction between the government and any other party, wherein the public officer in his official capacity has to intervene under the law. So, I don't know, some of you here practice this kind of like individual sa sanggunian, di ba? The sanggunian will authorize to, the mayor to enter into contract. But if the appropriations ordinance already has that, and the only things left is for them to implement, supposedly mag-execute na lang ang mayor. Ang bidding kasi nasa office of the mayor, and kasi it's an executive function. But I know that it comes to my knowledge that some of the sanggunian, every contract they will approve kahit nasa appropriations ordinance na yan. I don't know, it's a practice some of them have maintained since before, but it could open to a possibility, no? So, ang naging official capacity to naging ano kasi may intervention na sila. It could also dictate a lot. It could also open opportunities for corruption. Kasi naging, bakit kailangan sila mag-intervene na hindi naman kailangan? Diba? Actually, under the law, it's not required anymore. Meron na tayong maraming jurisprudence dyan na merong implied at express authorization. So, like for example, yung mga directly or indirectly, sabi nga, di ba, parang, uy, mag-post ba tayo, no hotel kayo, may airfare pa, tapos during Christmas, may pinapadalhan pa kayo ng mga aguinaldo. So, dati sinasabi nila, if it's given before the award, it's a bribe. If it's given after, it's thank you. Under our 83019, it's not even allowed. The thank you is not even allowed. Yes, just say, I mean, the best thank you is the delivery according to standards ng project or ng goods, no, ng infra or goods, or even the service sa consultancy. That's the best thank you. It doesn't have to be necessarily a bag, a shoe, a pair of shoe. No. Or a lechon for the Christmas party. No. Hindi kailangan na hiningi nyo. Kahit binigay lang sa inyo na hindi nyo hiningi, pero tinanggap nyo, it still amounts to the same thing, no? It still amounts to the same thing. You still, it's still covered under our 83019. Then next also, next slide, accepting or having any member of his family accept employment. Accept. Ang sabi dito ha, accepting or having any member of his family accept. Accept or having any member of his family accept an employment in a private enterprise which has a pending official business with him during the pendency thereof or within 1 year after its termination. So pag yung anak mo, empleyado na talaga siya dyan, tapos ikaw kasama ka sa bank, nakalagay kasi yan, di ba? May disclosure tayo sa relationship, no? So, hindi din pwede. Pero, yung ina-accept ka talaga, for example, lagi kayong nag-activity dyan sa hotel na yan, anak mo graduate ng management, tourism management. Ipapasok mo din. Kasi back secretariat ka eh, malakas ka, sa'yo lumalapit yun. So, that is a concrete example. Kahit nag-resign ka na, within 1 year of this termination, retired ka na, kasama pa rin yan. No, na kahit 1 year lang, for example, yung hanap ako ng idea ng contract. Kahit hindi na sila yung regular nyo na supplier, within 1 year after the contract termination, for example, infra, contractor, yung anak mo, engineer, 6 months after napirmahan yung contract, yung anak mo top notcher sa civil engineering board exam, hindi siya pwedeng i-hire dyan sa company na yan. No, until after 1 year after the termination of the contract. Hindi award na yung termination of the contract, meaning tapos na yung kontrata. That's an example. And another also, section 3E, next slide. Ito, catch all to, mahirap to ha. Ang kalaban nyo dito, Yung lahat ng hindi gusto, yung lahat ng feeling na lugi. Marami kayong kalaman dito. Causing any undue injury to any party, including the government, or giving any private party. Ito ha, causing undue injury to any party, including the government, or giving any private party any unwarranted benefits, advantage, or preference in the discharge of his official, administrative, or judicial functions. Ayan, na-mention itong tatlo kasi nga general tong RA 3019. Through manifest partiality, evident bad faith, or inexcusable negligence. So take note lang, whatever undue injury that is caused, it must be, itong tatlo dapat present to. May manifest partiality, bias na nangyayari during in the exercise of a particular duty. May evident bad faith. Ano? Alam na. Kaya nga kami, I'm more careful in my role as a back member. Hindi ako sign lang. Kasi hindi ako makakadepensa ng evident bad, ng good faith eh. Kasi sigurado na kaming bad faith kasi alam mo na batas eh. Tapos wala na, hindi mo na excuse. Especially as a lawyer also, at same time as a procurement lecturer, wala na. Bad faith na ako automatic pag may magawa ako. So yun. Tapos gross and excusable negligence. Not simple negligence but gross and excusable negligence. So, kasi this is the most often charge being filed by bidders to members of the back. In fact, this provision is now being abused since it is used by some bidders just to get even, no, revenge na lang, or to wage revenge against members of the back whom they seem to be critical to them. For example, nakulang sila ng isang paragraph sa OSS nila. Tayo pass-fail tayo. Remember, the OSS, the Omnibus Sworn Statement, dati, maraming iba-ibang affidavit yan. Iniisa na lang sila omnibus. Pag may mawalang isang paragraph dyan, it means may nawala din na commitment sa part nila. So pag nakulang yan, pwede silang i-fail. Tapos galit si bidder. Diyos ko, isang paragraph, hindi lang na-print kasi long from, kasi nga, di ba, minsan sa bond paper, hindi, yung long, iba pala is A4, tapos nawala yung ibang paragraph, ay pwede pong i-fail nyo again. Huwag kayong ito pa ulit-ulit. Sinabi ko din to last sa ibang batch. Huwag niyong pairalin yung awa nyo, especially sa pass-fail na stage, ha? Yung sa preliminary examination. Kasi kung awa yung nyo, remember, maraming matang nakatingin. No? Yung ibang bidders, yung kalaban ni Hope, lalo na si LGU, si Hope is the LCE. Election is coming, maraming kalaban si Hope. Nakatingin lang yan. Kaya as a back member, you should be circumspect in the exercise of your Huwag masyadong maawa, or kakilala naman natin yan. Sige, ihabol mo na lang yung document. Hindi pwede yan. Kung ano ang nandyan sa eligibility requirements, yun yung titingnan nyo. Pag makulang, ay fail. Diba? O pag may mga request for reconsideration or protest, it must be based on the law. Hindi pwede awa lang. No? Huwag masyadong mabait. Kasi hindi sila kasi kayo yung magsisuffer. At mga anak nyo, pag ina-attack na kayo ng mga radio na may mga black timer din na kalaban ng mayor nyo, ina-attack kayo, ang maiiyak anak nyo, hindi anak nila. So, careful. So, no, usually abuse to Pero, ang tatandaan nyo lang, pwede silang magdemanda sa inyo anytime because you're public officers, you're open to anytime sa mga accountability suits. Pero as long as you don't have a manifest partiality in the exercise in the performance of your duty, there's no evident bad faith on your part, and you are careful na walang gross and excusable negligence, then that is your defense. That is your defense, na hindi siya pasok sa tatlong yan. So, also, ito din, entering on behalf of the government into any contract. Natawa. Sorry, lakas ng tawa ko sa comment. Matakot naman tayo nito, ma'am. Oy, from Julia Talalayo to everyone. Lakas ng tawa ko dun. Hindi naman matatakot basta may depensatan tayo, no? Kasi open talaga tayo for suits, no? Kasi nga, public officer tayo Pero basta nasa tama lang tayo, wala tayong kakatakot. And also, try to not follow kaagad dahil yun ang ginagawa ng iba. Just read lang. Simple read ito, may training nga kayo, inallow kayo ng hope nyo to spend a relevant portion of your time in the office to learn. Kasi ayaw din ni Hope na makulong. No? Gusto niya matuto din kayo. Anyway, ito din. Entering on behalf of the government into any contract or transaction manifestly and grossly disadvantageous to the same. So sabihin natin, this provision covers all procurement transactions no, with overpriced contract amount. This is because any overpriced transaction is grossly disadvantageous to the government. Hindi ibig sabihin walang bidding, grossly disadvantageous to the government na yan. Kasi di ba nga, na-discuss sa inyo ni Sir Absal. Sir Absal is my batchmate sa JPPB. Yung nag-discuss sa inyo sa alternative modes na hindi, kahit negotiated kayo, it is not automatic na disadvantageous. Na ang advantageous lang yung competitive bidding. The fact that it is allowed by the law, it means, it means the lawmakers sees it as not disadvantageous to the government. It is not put in there that provisions on alternative modes para malugi ang gobyerno, kundi para mapabilis lang yung mga transactions, not necessarily para malugi ang gobyerno. Now, kahit may bidding pa kayo, pwede din na maging grossly disadvantageous pa rin siya. I will point out a certain practice which I know is happening in the LGU. Yung municipality ng sana walang ganitong municipality. Yung municipality ng Kampotpot, nag-procure sila ng ganitong truck. Magkano daw? Wala, 1 million. 1 million flat yung ABC nila. Kayo, hindi na kayo nag-market analysis. Biyahin na lang natin yung nasa nila, 1 million din. Tapos yun pala, nag-rely kayo sa kabilang municipality, nagkopyahan. Maraming kopyahan ng mga ganyan eh. Kasi magkakaibigan naman kayo same position, di ba? Nag-aabot-abot kayo sa mga training, lagi lang sa DILG. So, nagkopyahan. Di mo alam, hindi na pala sila nag-market analysis or nag-market analysis sila. Sabi nila, mag-procure tayo ng ganitong heavy equipment. Sige, punta ka doon sa tindahan na yun, tingnan mo, magkano price niyan. Isang tindahan na pinuntahan, ganito yung presyo namin. Talaga, sige, lagyan na natin ng ABC. 960,000 yan sa amin. Sige, i-flat na natin 1 million para pasok pati yung ibang bidder. Tapos hindi mo alam na yung 960 pala yun, 1,000 pala yun pala yung sa market pala, sila pala yung pinakamahal. Kasi dapat pala, kasi yung market analysis kasi, yung ABC nyo, nag-range yan from between sa pinakamahal at pinakamura. Kayo yung reasonable nyo yung i-determine eh. Kayo, nasa inyo yan, magde-determine. Kayo yung maasa lang kayo, anong bigay ni end user thinking, na market analysis na yan. Kinopya lang or isang lang yung tinitingnan. Hindi tiningnan yung ibang suppliers anong possible price, SRP sa certain equipment or item. So, naging later na siya, na overpriced. Kasi nga, marami pala sa market niya na 700 o 600,000 lang. Anong masama, ma'am? Kasi ganito yan. Minsan kasi, pag sobrang lobo, alam naman natin na posibleng mag-usap-usap yung mga supplier. Pag lumobo yan, susulitin niya yan. Kung 1 million sasabihin mo, magbibigay lang yan ng offer 999,999 pesos and 99 centavos. Diba? Gaganito niyan. Paano tayo sige lang, pasok naman sa ABC. Pasok nga sa ABC. Pero had it been my market analysis na proper, had it been you were doing during pre-procurement activity, kung meron man kayo, kung required man, na-discuss nyo kung yan yung all aspects ng procurement, hindi sana ganyan. Hindi sana tayo malugi. May mga ganyan pala na 600 or 700 lang. So sana na-set yung price in the mids, range. Kasi wag masyadong i-accommodate natin yung profit. Kasi atin is may profit sila, but hindi din tayo lugi. Hindi naman tayo Santa Claus yung gobyerno. No? So, kahit nga isda, tinatawaran nyo, di ba? So, this provision, minsan, di ba, pabalik-balik pa tayo, ilang shoes pa ang ipifit natin bago tayo babalik. Ito pala, dito pala tayo. So, it all covers. Hindi yung gross manifest or grossly disadvantages to the government, hindi yan i-determine based kung may procurement o wala. I-determine yan based sa price na siniset nyo or sa paano nyo pinocure yan, paano nyo siniset yung ABC nyo, paano nyo siniset yung mga technical specifications nyo. Baka naman mamaya kahit hindi kailangan ganyan na computer ang pagbibilhin nyo, ganyan talaga bibilhin nyo, pang gamer. Ako aaminin ko, may mga iba talaga, how dare them. How dare them. Kasi nga ako may iba talaga parang, request tayo ng gamer chair. Bakit ka magi-gamer chair? Gobyerno ka. Yan, swivel chair mo, yan puan mo. Magi-gamer chair kasi matagal daw silang makaupo habang gumagawa ng mga ganito. Ba't ka magi-gamer chair? Mas iba yung presyo nun. Sabi ko, kailangan ba? Yun lang talaga. Kasi sa COA, di ba, meron tayong mga unnecessary, mga expenses, ganyan. Ingat, yun yung titingnan nyo. Necessary ba? Otherwise, baka disadvantages na. No? So, applicable penalty also for R83019. I have to wrap this up. Applicable penalty also for R83019 is yung 6115 pa rin. Imprisonment for not less than 6 years and 1 day, but not more than 5 years. So meaning di pa rin eligible for probation. Naalala ko law school, sabi. May isang, accused, nag-request na alisin na lang yung 1 day kasi nga gusto niya mag-apply ng probation. Ay set po yan. Kasi po hindi i-impose ng imprisonment yung courts kung hindi siya yung nakalagay na prescribed penalty. Hindi po yan, ang discretion lang po ng courts is kung ano yung i-set na penalty from minimum to maximum, pero hindi po yung siya yung mag-decide na ay ito na lang 3 years na lang, 2 years na lang. Unless kasi remember, this is a special law. I don't know, any of you have background in law? This is a special law. This is not so it's pag special law kasi, malum prohibitum. Bawal dahil pinagbabawal. Mali dahil pinagbabawal. Hindi mali dahil per se, mali siya. Like for example, pagpatay, pang-rape, mali dahil mali talaga. Ito, malum prohibitum to. So, yung mga prescribed penalties, hindi siya pwedeng applyan ng mga mitigating at aggravating na circumstance. So, kahit ano pa yung reason mo na pwede sanang i-mitigate, matanda na ako, may PWD ako, manganganak ako, hindi to mag-applyan. Unless talaga. So, yan. Meron din dito disqualification from public office. Unlike RA 9184, disqualification to public office could be temporary or perpetual. Pero sa RA 3019, pag ito ang ikinasa sa'yo, perpetual na yan. Hindi ka na makakabalik either as an elective official or as an appointive official. And same din sa private individual na involved. Kahit nag-top pa siya sa bar exam later, yan nga, di ba, sa bar, kailangan wala kang kaso talaga, etc. Otherwise, hindi ka, kahit papasa ka, hindi ka makapirma sa roll of attorneys. For example, kahit dati, ikaw pa yung top notcher ng civil service exam, pag later on ng civil engineering board, pag later, ma-disqualify ka from public office, hindi ka na pwede mag-apply sa gobyerno. No? Not only that, confiscation, of course, or forfeiture in favor of the government. So, pasok pa rin yung confiscation or forfeiture in favor of the government under RA 3019. Sa any prohibited interest and unexplained wealth. So, paano mo nila i-determine na unexplained yan? Based yan sa sweldo mo. Based yan sa declared income mo. Kahit maliit ang sweldo mo, pero marami kang racket. For example, may mga negosyo ka, kunyari, YouTuber ka, di ba? Kaya ngayon, stricto na yung BIR eh. I-declare mo lahat yan. Pati yung, kunyari, may share ka sa company ng parents mo, i-declare mo yan. Otherwise, kung titingnan lang yung sweldo mo, tapos ito yung kotse mo, ito yung ilang kondo meron ka, baka ma-unexplained wealth yan. Nakakahiyaman, di ba? Parang sabi natin, puro naman utang yung andon sa salin ko. Ay kahit puro utang yan, may asset pa rin yan, di ba? For example, utang dahil amortization, dami mo na palang binabayaran na kondo. So, yan din yan. Yung, then market trace. I also do lifestyle checks. Especially, Ombudsman will always ask the ALG to do fact-finding investigation. I also do lifestyle checks, no, sa iba. Tinitingnan namin yung mga Facebook nyo. Hindi masyadong mayabang sa Facebook yung mga tao eh. Alam mo saan mayabang ang yung mga tao? Saan mo mahahanap? Tingnan mo yung Instagram ng mga anak nila. Tingnan mo yung Instagram ng mga anak nila, saan-saan na sila nagta-travel at ano na yung mga bags at shoes nila. Saan sila? So, doon mo makikita kung may unexplained wealth na, manifestly out of proportion of the salary or lawful income. So, let's go to protest. Tapos na tayo no, sa first part, yung penal, civil, and administrative liability, tsaka yung second part na R83019. Now, let's go to the protest mechanism before we go to the blacklisting guidelines. Protest mechanism is ito yung remedies ng prospective bidders or suppliers if in case they're not happy with your resolutions or decisions during the back procurement. So, we will start with the filing of request for reconsideration. Why do we have to start with the filing of request for reconsideration? Just like the motion for reconsideration, a request for reconsideration is actually due process favorable to the back. Pag may mag-file sa inyo ng request for reconsideration, it's actually the observation of due process in your favor. Why? Because it is your decision or resolution that is being asked to be reconsidered. Binigyan kayo ng chance na i-reconsider yun kasi nga baka naman may lapse talaga kayo, may hindi kayo na-appreciate, may mali kayo. At least hindi kayo ididiretsong idedemanda. Diba? They have to go through the filing of RR first to give you a chance to correct yourselves. Ito dadaan to sa back. Yung RR is nasa backstage to. It is filed by the aggrieved, not just the prospective. The aggrieved supplier or manufacturer or bidder or even the other observers within 3 calendar days. No? Within 3 calendar days upon receipt of the written notice or upon verbal notification. Now, usual tong written notice, for example, siya yung lowest calculated bid. Tapos, during post-qualification or bid evaluation, during bid evaluation, hindi pala siya yung lowest kasi may mali lang sa computation. Or during post-qualification, he was found to be disqualified. Yung 3 calendar days will start upon receipt of his written notice or upon verbal notification actual during the opening of bids and the actual opening of bids, nagsasabi na siya, na-disqualify siya sa pass-fail. So, sasabihin na niya, I will file a request for reconsideration. Okay, that's taken into consideration. That's parang notice na yan. That's a notice already na mag-ano siya ng file ng R&R. So, may verbal notice from the back that he failed, then he will file R&R within 3 calendar days. So, hindi sinasabing 3 calendar days, kasama Saturday, Sunday. For example, now, today is Friday. So, kunyari, may opening of Bisaya, 3 calendar days, Friday, Saturday, Sunday, Monday. So, Monday yan, magpa-file ang deadline. If Thursday, kahapon yan, nangyari, Friday, Saturday, Sunday, magpo-fall sa Sunday. But since wala tayong government office sa Sunday, bali, yung next working day, dun na siya yung deadline. Hindi morning, whole day pa rin. Hindi, sabihin kasi Sunday nga yung deadline yan eh. So, dapat morning nasabit nyo na hindi, ganyan. When you say office calendar days, it includes up to the last day that you are open. Hindi din sinabi, actually, wala din sinabi na hanggang 11:59 ng gabi. Wala naman. Kasi wala na ding office. It's not reasonable for us to wait for them until 11:59. So, then, after that, matanggap ng back, then they will have to decide within 7 calendar days. They will have to come up with a resolution. Why would I say resolution? It's because the back is a collegial body. Diba, grupo kayo? Jury duty nyo yan. So, back shall issue a resolution within 7 calendar days from receipt of R&R. If granted, then balik kayo kung saan na point yun. Kung nyari siya yung lowest calculated bid. Tapos during post-con, pinapost disqualified nyo, tapos nag-grant nyo. O di balik kayo doon siya uli yung lowest calculated bid kasi mali pala yung nireconsider nyo yung disqualification nyo. Or if nag-fail sila during the opening of bids, pwedeng balik kayo uli doon. Kasi di ba may procedure during the back opening kung anong gagawin sa mga nag-inform na magpo-protest sila. However, most of the time, it's denied. Kasi nga, di ba, when you declare a bidder, prospective bidder or supplier, disqualified either during the opening of bids or during the bid evaluation or during the post-qualification, it is based on law. May kulang sa kanila. So pag na-deny nyo yan, yung denial din at grant, it's still based on law and not for humane consideration. Wala po tayong place or humane consideration na kahit masama ugali natin, okay lang yan. Oh. Di ba, ling is na, basta wag lang corrupt. So, if RR is denied, the decision of the back may be protested in writing. Kung deny na, it may be protested by the and in writing na din. No? So, ang tandaan lang natin is 377, yung 3 calendar days. Yan, tapos 7 calendar days din. From receipt of the back resolution. So, a prior R&R is a requirement before protest. Yun talaga. Ang dapat may request for consideration sa address to the back before a protest may be filed before the hope. So, there must be a request for consideration addressed to the back and resolved by the back before a proper protest can be filed before the hope. So, yung protest sa hope na yan. Let's go to the next slide. So, bali yung protest, yan yung parang appeal. Parang appeal nyo sa resolution ng back. Kasi hindi nyo nakuha na i-reconsider ng back yung resolution nila to disqualify you. So, prospective bidders price now will appeal that resolution to the hope through a verified position paper and after payment of non-refundable protest fee. So, for the protest fee, there is actually a range for that, no? Depende sa ABC, magkano din yung protest. Hindi siya fixed price, hindi siya fixed percentage. It really depends on the amount of the ABC. So it must be, the verified position paper must be in writing. And it must be accompanied by proof of payment sa non-refundable protest fee to be paid in cash. Cash po, wala na pong letters of credit dyan, tsaka wala na pong bid securing BSD dyan, ha? Cash na talaga yan. And certificate against forum shopping. Baka naman mamaya, nag-file pa lang sila ng request for consideration or protest before the procuring entity. May kaso na palang nakahintay sa Court of Appeals or sa RTC. So, dapat transparent. Why? Because meron po tayong, this is considered an administrative remedy. So, meron tayong attachment sa jurisdiction. Ako ba ang may jurisdiction para mag-decide nito? Or marami kang binibigyan ng jurisdiction mag-decide sa isyong ito? No? So, ito, next slide. This is an example of the verified position paper. So, yan. As long as ang cover letter niya, there must be a bidder's name, an office address, the name of the project or the contract. Kasi pwede kasi isang bidder, marami siyang contract dyan sa procuring entity, no? Ulit-ulit siya. Implementing office or procuring entity, brief statement of facts, issues to be resolved, and other matters. There must be an issue to be resolved. Hindi pwedeng, dapat may mali siya na na-point out. And that mali is the issue, and that is the issue that to be resolved. Hindi pwede yung request for reconsideration at verified position lang na nangihingi lang ng konsiderasyon sa inyo na pagbigyan nyo na. Dapat may hindi pwede yung walang ground siya na i-raise. Dapat meron siyang ground na i-raise para yun yung issue na i-resolve nyo. Kung simple na nagmamakaawa lang, hindi po yan pwede, ha? Hindi niya, kulang siya. Pwede nyo i-dismiss yan. Other matters. So, yung position paper nyo, bakit kailangan verified? Because especially in big corporations, it's the lawyers who prepare your position paper. Baka naman mamaya, kayo pirma lang kayo na pirma, di naman yun yung actual na nangyayari. Kasi kayo yung andoon sa bidding, yung opening of bids, kayo yung alam yung nangyari, anong nangyari doon sa opening of bids, tapos yung lawyer yun yung ang nag-prepare ng position paper nyo, kung ano-anong pinaglalagay doon sa content ng verified position paper. So dapat verified talaga, hindi affidavit lang, verified talaga yung position paper nyo na you as the affiant, either the prospective supplier or the manufacturer or his authorized representative has read and understood the contents ng verified position paper and that the allegations therein are true and correct based on his knowledge of the facts or authentic records. So, If unverified yan, tapos walang certification of of non-forum shopping, tapos wala pang proof of payment ng 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 protest fee, then it is a ground for dismissal, no? Outright dismissal of the protest for what? For failure to comply. No. So that is not curable na pwedeng ihabol. Pagkalampas ng 7 days after the back resolution on the request for reconsideration, nag-submit ng verified position paper pero walang proof of payment ng protest fee, or merong proof of payment pero hindi verified yung affidavit, hindi pwedeng ihabol sa 10th day yung proof of payment tsaka yung verified na version ng position paper. Walang cure. Bakit walang cure? Kasi sa court kasi meron kami tinatawag na magli-leave of court to cure our defects. Pero sa atin kasi wala kasi yan eh. Sa Hope, hindi naman court si Hope eh. Ano lang siya, nag-exercise lang siya ng quasi-judicial function, no, for administrative sanction. So the resolution of protest, no, if denied yung request for reconsideration, may file na 7 calendar days to protest. Hope shall also resolve the protest within 7 calendar days from receipt thereof. So always remember 3, 7, 7, 7. Karamihan talaga pag ang government ang required to take action in this, para dali nyo remember, 7 calendar days or 15 for other yung sa blacklisting. Pero sa prospective bidders or suppliers or aggrieved party, mas shorter yung period nila. No, except for the filing of protest kasi nga kailangan verified position paper. They need to prepare it pa. So the Hope shall resolve the protest within 7 calendar days from receipt thereof, and the head of the pack shall furnish the bidder with a copy of the decision within 7 calendar days from receipt. So pag walang ito na yung tinatawag na final and executory at the level of the procuring entity. After ma-inform sila within 7 calendar days from receipt of the prospective bidders or suppliers or the aggrieved party of the decision of their protest. Now, is there another remedy? There is actually another remedy, di ba? Any protest, next slide, any protest taken from any decision treated in RA 9184 shall not stay or delay the bidding process, no? Provided further that the protest must first be resolved before any award is made. Punta muna tayo dito. While ongoing yung request for reconsideration or yung protest, ano ang mangyayari sa procurement activities? Tuloy-tuloy pa rin po yun. Hindi po siya magsistay or mati-TRO. Huwag po kayong maniniwala pag sasabi, pati-TRO ko yan. Why? Because as I've said earlier, it involves a government project. And government project do not delay. Sabi nga ng 10-wheeler truck na dumaan sa bahay ko. So yun, IRR and RA 9184, mga mechanisms on protest shall not stay the bidding process. It will continue. However, hindi pwedeng mag-award unless ma-resolve yung protest. Now, after na-resolve yung protest, pwede na pong i-award. It doesn't matter if meron pa siyang another action sa proper courts unless makakuha talaga siya ng injunction, which is very rare. There are certain projects na pwedeng even the Supreme Court can enjoin. But most of the time, it cannot. No, damages na lang mahahabol nila. So where the protest was not verified and protest was not fee, ito, di ba pwede pag hindi verified yung protest at yung protest fee hindi nabayaran, di ba pwede nyo i-dismiss? Pwede ba siyang mag-proceed to regional trial court for that? Kasi nga na-dismiss na siya. Hindi din. Bakit? Kasi nga dahil nag-fail siya sa protest mechanism, it is considered na hindi niya na-exhaust yung administrative remedies. No? Hindi niya na-exhaust yung administrative remedies available to him. Because there is in the revised rules of court, the doctrine of exhaustion of administrative remedies, where the lack thereof, kaya nga tayo, diba, dumadaan pa tayo sa barangay pag may mga demandahan, may mga kasong kailangan pa idaan sa barangay. Kasi po, meron niyang administrative remedies available, just like here in RA 9184. Pag di dumaan dyan yan, i-dismiss yan ng court for lack of jurisdiction, no? Under Rule 16. Lack of jurisdiction yan. So, Pag yun yung ground ng dismissal ng protest, hindi din siya pwedeng dumiretso sa RTC, yung aggrieved party. So, court action may be resorted to only after the protest shall have been resolved with finality. No? Tapos na yung 7 calendar days after i-notify ng back secretariat yung aggrieved party sa desisyon ni Hope. At the same time, yung decision was not on the ground na dahil hindi verified or hindi unpaid yung protest fee. So, protest fees. Ito yung range ng protest fee. Depende siya, nakabase siya sa ABC range. I was doubtful before. I remember first time saying this in 2012. Kinumpute ko talaga. Kunyari, 50 million pesos and below, 0.75 of the ABC. So, kinumpute ko yung 0.75 kung talagang 50 million pesos. Hindi ba siya, baka naman mas malaki pa siya sa 500,000 na next ng level ng protest fee. Hindi, talagang magaling pagka-compute nila dyan. Talagang, hindi, di ba may mga ibang, may mga instances na minsan, buti pa ito na lang ginawa mo kasi mas lower pa yung penalty sa'yo kumpara sa ganito. Ito, talaga tamang-tama yung computation na. So, yan po yung protest fees natin. It hasn't changed yet since 2012. Siguro nakita nila there's no need na. So, let's go to the knowledge check again before we end our discussion.
All right, Attorney. So, we have come to the last knowledge check for this first session. So the question is, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the Hope not to entertain a protest. A, true. B, false. Again, the non-payment of the protest fee does not toll the prescriptive period for filing a protest, and it becomes a justifiable basis for the Hope not to entertain a protest. Is it true? B, false. Again, to all participants, kindly choose your answer to our Zoom polling feature. All right. I guess majority of our participants is choosing true for this specific poll. Again, please key in your answers in 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. There we have it po, Attorney. 95% answered true, while there's a 5% who answered false for the specific poll. Ano po ang tamang sagot, Attorney?
Yeah, it's actually true. No, the non-payment of the protest fee means that your protest is not valid. Hindi siya valid. So hindi siya in the first place, even if valid protest, kasi siguro yung 5% nalito kasi because of the manner the question was being asked. With or with even during the protest mechanism, even with a valid verified protest verified position paper, or even with the payment of protest fee, hindi talaga magtotol yan. Walang makakapagtol sa prescriptive period for filing a protest, no? So 7 days lang talaga siya after the issuance of the back resolution. So kung hindi verified yung position paper mo, hindi mo mabayaran yung protest fee, thank you na yung opportunity ng prospective bidder to file a complaint, and he cannot even go to court. Okay, so siguro nalito lang. So tama, ang dami nakakuha. Magagaling sila lahat. At, sige, hindi ko lang sasabihin. Parang itong batch na to nag-aral ka before. Parang inaral. Parang feeling ko, nag-aral na ba kayo before dito? Baka nag-review na kayo, ha? Itong batch na to.
It is just impressive, Attorney, na this batch are listening to our speaker.
Yes.
Yes.
I'm so happy. So, that's our last knowledge check na, di ba?
Yes po. So, that is the end of our first session. So, we would like to thank Attorney Nogra for the comprehensive discussion for the protest mechanisms and remedies. So, we will be having a short break. We will be having a 5-minute short break. So, for all to all participants, you may have your CR break, or for some, you can accomplish our requirements just say like the evaluation and OTMS registration. So again, see you after 5 minutes break. Thank you.
Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files. Have you ever wondered how sharing of issued blacklisting orders could be made easier for your agency? Well, with the Online Blacklisting Portal, or OBP, you are only one click away from posting and updating the status of your blacklisted entities and accessing information related to your agency's blacklisting history. Let me give you a quick walkthrough of the new OBP. To register, visit the link flashed on your screen. One registration per PE is allowed and only the official user can request for registration. After the successful registration, an alternate user can be added. Your registration will be validated upon receipt of the documents flashed on your screen. Within 3 days from the effectivity date of the BO, PEs should be able to post the BO by filling out the form in the OBP and uploading the copy of the approved BO. You can simply click on the Update Update Status tab from the Blacklisting Order Details screen. In case you need to change or update your account details, you may send a request to the email address flashed on your screen. For more details, you may visit the OBP homepage to access these files.
All right, what you have watched is the AVP of the online blacklisting portal, which is it shows the step-by-step process on how you can utilize the said portal. So again, we're going to move on to our discussion of our next session. So we welcome again our resource speaker, Attorney Isa Nogra, for the second session of our today's topic, blacklisting guidelines. Again, Attorney.
Hello, good morning. Tapos na tayo, no? Mag-break, no? Nakakatayo na rin. I know, it's quite difficult to be sitting on 4 hours straight. Unlike sa pag may venue tayo, pwede pa tayong tumayo para magkape. Pero wala tayong chance dito eh. Nakapin na tubig lang. So, we will proceed with the next topic. Supposedly, this is part of the protest earlier topic, but I'm glad also na siniparate na kasi especially now that we have already this online portal, online blacklisting, then it has also to be separately discussed. But before I proceed, may nalimutan pala ako. Earlier kasi, napansin ko lang, wala sa module ng GPPB, but if you have a chance, try to check also Section 73 and 74 of of the revised implementing rules and regulation, or even nasa RA 9184 din yun eh. Yung mga private legal assistance, indemnification of back members, or even medical assistance, try to check on that. Para alam nyo din, kasi baka isipin nyo, ay ayoko na mag-back, kasi baka mademanda ako. Kung i-demanda, maghirap ako nito. Baka maubos lang yung makuha ko dyan. So we also have a provision on that regarding the compensation. Unless, of course, you're found to be guilty after, no? So on appeal, kanya-kanya na kayo. So anyway, it's just I just discussed in passing. You can just read it through it. So we'll proceed to the blacklisting guidelines. So, by end of this, punta ulit tayo sa expectation setting. I always start with expectation setting. So by the end of this module, no, you as participants, we expect you to be able to first understand the procedures already in imposing administrative sanctions in the form of blacklisting, and of course, suspension, no, to bidders who committed any of the violations during competitive bidding or contract implementation stage. Then second, of course, to obtain or gain substantial knowledge on the responsibilities of your back, you as a back secretariat, or even for the observers and bidders and end users or implementing units relative to the issuance and posting of the blacklisting order. Like in my case, although I'm a back member in my own agency, I also act as observer most of the time to some agencies who invite me. So, yun. It could be useful also. I know a lot of you may say that keep on inviting observers, but they don't come. But some of them, they could come, and some may mga corruption CSOs kasi focus on corruption, anti-corruption, and they could, if you invite them, some of them are really knowledgeable din sa RA 9184. So, dapat din may malaman tayo yung hindi tayo as nasa gobyerno, representative ng procurement, hindi tayo pa ang less ang knowledge. Dapat more ang knowledge natin kaysa sa kanya. Kasi di ba minsan magagaling pa ng mga suppliers o ng mga observers tayo, tapos tayo pa yung medyo, paano to nga. So, dapat hindi ganon. Kaya ito yung purpose ng objective natin. Alam din natin yung mga procedures. Kung in case may mga kailangan i-blacklist. So, outline of the discussion will be first, we will discuss the uniform guidelines. And then second and third, we will discuss both blacklisting procedure during procurement stage and during contract implementation stage. So, blacklisting doesn't happen only against prospective bidders and suppliers and manufacturers. It could also happen to those contractors already who have been awarded with a contract. So, iba-iba ang procedure kasi iba-iba na yung at stake. With the bidding during procurement stage, What is at stake is only the bidding procedure. Marami pa namang ibang bidders, di ba? Tsaka may bid security tayo. But when it comes to the contract implementation stage, of course, ma-affected na yung mga projects na ongoing. Tapos, yung performance security, andyan din naman yan. Pero yung most, yung top concern natin is what will happen to the project, especially ongoing na siya. So, uniform guidelines and blacklisting. So, what are the guidelines issued by the GPPB when it comes to blacklisting? So, prominent to this are the two GPPB resolutions, no? Number 40, series of 2017. Next slide po. At ganan-ganan ka lang siya, ha? At number 14, series of 2020. Basically, talaga, itong blacklisting na to, alam naman natin, GPPB has the Government Procurement and Policy Board, has a policy making authority, where they can even add or supplement or interpret extensively the provisions of the law. Unlike us, kami sa DLG, there are limits when it comes to substantive policy making, kasi minsan naging substantive legislation na sinasapawan na ng mga executive agencies yung policies, yung legislative intent. But when it comes to GPPB, they can issue this because the law itself allowed them to. If there's one law that I've seen as very dynamic instead of static, kasi may mga kinds of law kasi yan. Ano yung movement ng law? RA 9184 is a very dynamic law. It changes often and it grows very fast. Bakit? Kasi every day, like right now, at this certain point of time, ilang agencies kaya, either local or national, ang nagpo-procure with ongoing bidding. Di ba? Ang dami. Buksan natin yung field jobs, ang daming posting. That is why it keeps on growing. Every time may procurement, may nai-encounter na problem, which requires intervention or further interpretation. So that's why this law is dynamic. It keeps on growing, and the legislature cannot take the responsibility of updating it always. Kailangan naman balik ng balik sa Congress. So that's why some of their tasks, they delegated it already to the Government Procurement and Policy Board para kayo na ang mag-update. Kasi mahirap pong balik ng balik for amendments or sa legislature. Because it's very dynamic. Di mahahabol. Huh? Like right now, we have this COVID situation thing. Kung wala pang policy making yung JPPB, mahirap. So same with the blacklisting. If there's one thing about this blacklisting, bakit siya kailangan nating i-update lagi? These prospective suppliers and bidders are very innovative, not only in delivering or performing their task, but also in not delivering and performing their task, no? They're so innovative in finding ways to the detriment of the government minsan. So kaya tayo, laging updated yung natin. At uniform natin yung guidelines natin. Also, the reason why we made it uniform yung guidelines to make sure that there's no partiality. No? Hindi, ay, mas stricto dito, ay, mas stricto doon. Hindi ganon. No? So kaya meron tayong uniform guidelines. And then come 2020, because you already have the online blacklisting portal, then another resolution was issued also by the GPPB. And you can access that online blacklisting portal later on. Pwede nyo i-tasos kasi na in-advertise kanina, di ba, running. So, yan. Lahat siya. So, ito, mag-define tayo. What is the difference between blacklisting and suspension? So, ganito na lang. Blacklisting is an administrative penalty, whereas suspension is an interim penalty. Blacklisting is an administrative penalty, disqualifying a person or an entity from participating in any government procurement for a given period. Okay? It's an administrative penalty na disqualify na ang person or an entity, natural or juridical, to participate in any government procurement for a given period. Hindi lang yung mga procurements sa particular procurement entity. procuring entity. No? So, the blacklisted person or entity was disqualified by the agency and is included in the GPPB Consolidated Blacklisting Report. So, yun sila. Yun yung blacklisting. How do we compare it with suspension? Suspension is merely an interim penalty. It could be 1 year or 2 years, no? Imposed for infractions committed by a bidder during the procurement stage, whereby such bidder is prohibited from further participating in any of the bidding process of an agency. Bali, yung suspension, dyan lang siya magti-take effect within the procuring entity, no? Hindi siya kasama doon sa yung ibang government agencies. But suspension is the first stage before you blacklist. You cannot blacklist without suspending, no? It shall be effective during the period of motion of reconsideration and or appeal and shall terminate only upon final decision by the hope or appellate authority favorable to the, ito tatapusin ko yung sentence kasi hindi masyadong natapos. Kasi kung suspension mo 1 year or 2 years, during the time na may motion for recon pa yan or appeal, nagti-take effect na yan yung suspension ng prospective bidders, no? Even and only upon final decision na nilift yung suspension, saka lang din malilift yung na hindi pala siya guilty for this infraction, saka pa lang malilift yun. Pag yung final decision by the or appellate authority finding the prospective bidder or manufacturer talaga or supplier na guilty siya of this infraction, then he will continue his suspension for 1 or 2 years. It depends, no? So it varies. So, yan yung difference ng suspension at blacklisting. Blacklisting has a wider coverage than suspension. Okay. So, what is a delisting? So, automatic din yan. Pag blacklisted ka na, either you're a natural person, or a juridical person, an entity, company, corporations, or entrepreneur, or a partnership, automatically delisted ka after the period of for the penalty has elapsed, no? Mawawala ka din doon sa Consolidated Blacklisting Report. It's the removal. Pag hindi ka mawala doon, ikaw prospective supplier, sumulat ka na, mag-appeal ka na sa GPPB. Baka mamaya nalimutan. Pero supposedly automatic yan. So, scope of blacklisting, sino ba ang mabablacklist? 1, the individual or sole proprietors. If you're a bidder, your spouses, no? Kung individual ka or sole proprietor, meaning sa DTI ka naka-register, hindi sa SEC. So, yung bidders, yung spouses niya, kasama yun sa blacklisting. Kasi nga, di ba, may conjugal, may ownership na absolute community of property yan. So, partnership. Sino ang blacklisted din na partnership? The partners itself and its partners. No? The partnership is blacklisted. The partners are also blacklisted. So if the partners are directors of another corporation, then that corporation cannot, if for a controlling interest of more than 20%, then that corporation is also blacklisted. No? Kasama, damay-damay. How about cooperatives? Only if the cooperative itself and its members of the board of directors, general manager, or chief executive officer are also blacklisted, can also be blacklisted. Then partnership, joint venture, or consortium. So that's why yung pag may mga JVA kayo na nakikita, consortium ng dalawang corporations, you have to check also their SEC registration of the individual corporations or entity kung wala bang blacklisted doon, no? It's easy to say, may omnibus sworn statement naman, we can rely on that. Remember, we are supposed to exercise high standard of ethics, diba? Due diligence sa part natin, huwag excusable negligence, especially if it's really obvious, no? Na balita na yun, grabe, may balita sa corruption sa kanya, inspect nyo naman. So corporations, it could be an OPC, it could be a LLC, limited liability corporations, or one-person corporation, or a stock corporation. For as long as the single stockholder has at least 20% controlling interest, yung corporation, kasama yan sa mabablacklist, kahit ibang corporation. Yung corporation naman who are guilty of offenses or infractions which can be blacklisted, yung directors din niya at saka mga stockholders niya kasama din, no, sa mabablacklist. So, yun yung concept ng sino ang covered ng blacklisting at sino at ano yung mga this one. Hindi pala. Na-skip ba to? Ito, yung appellate authority. Ay, sa amin, applicable to. Kasi for example, kami, delegated authority yung mga regional at mga provincial, mga sub-back namin. But when it comes to LGU, ang hope kasi ninyo is the mayor. And wala pong appellate authority yung mga governor. Emphasize ko lang ha, or si congressman. Wala po siyang appellate authority. Because we have to go back to the local government code where municipalities and even barangays, cities and provinces have separate corporate personality. Other than their political function, they have political personality. They also have a separate corporate personality. Hindi po kayo component na under kayo sa branch. Hindi po kayo cities and municipalities. Hindi po kayo branch ng provinces. Wherein, pag may mag-aapila sa mga desisyon ng hope nyo, doon sa pupunta sa governor. Lalong hindi sa congressman. So basically, itong appellate authority na na-mention dito, as applicable lang ito. Sa inyo, hindi siya applicable. They have to go to courts if they have other complaints. Hindi sila kontento sa ano lang. So yun lang ha, wala appellate, may appellate authority sa inyo. Hindi DILG din, hindi DILG. Kasi wala kami ano kasi yan supervision versus control. Supervision lang kasi meron kami sa inyo, indirect. So yun. So now can we go to the knowledge check preliminary?
Okay, so we are now on the first knowledge check to our second session. And the question is, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Is it true or false? Again, blacklisting is an interim penalty imposed for infractions committed by a contractor during competitive bidding stage, whereby such contractor is prohibited from further participation in the bidding process of an agency. Again, kindly choose your answer po to our Zoom polling feature. At this time, medyo naghahati po ang kanilang sagot at ayan, lumalamang na po ang mga sumasagot po ng false. So again, key in your answer in 10, 9, 8, 7, 6, 5, 4, 3, 2, and 1. There we have it po, attorney. 73% po answered false, while 27% po answered true. Ma'am, ano po ba ang tamang sagot for this question po?
Actually, the right answer is false. But I will attribute to the confusion of those who answered true. Kasi nga, sa word na blacklisting. Kasi that paragraph is very correct except for one word. Blacklisting. It is supposed to be suspension. Yung nilagay kasi nila is kinorek lahat. Tamang-tama talaga yung pagkaka-define ng term except for the what is supposed to be defined itself. So, instead of blacklisting, palitan lang yan ng suspension. Perfect na talaga yung pag-quote. So, yun yung, I think there lies the confusion. So, interim penalty po yung suspension. Administrative penalty po yung blacklisting. Yung suspension, it covers only suspension within the procuring entity procurement activities. Whereas blacklisting, it can involve any ang blacklisting, hindi na din yung contractor pwedeng mag-participate sa procurement activities ng all other government agencies once nasa consolidated blacklisted report na sila ng GPPB. Okay? So, mas malawak yung blacklisting kumpara sa suspension.
All right, attorney. So let's proceed po sa ating discussion.
So, we will go with the blacklisting during procurement stage. So, ano nga ba yung blacklisting during procurement stage? Remember with my discussion earlier on both these mechanisms, yung CCCF, it's still almost all of the same sa RA 9184. Except yung sa RA 3019 ha, na mas yung mas stiff yung penalty. Yung mga offenses I mentioned earlier in RA 9184 are still the same ito sa blacklisting during procurement stage. Siya yung mga ground pa din. Let's go to the next page and examine ko yung mga pasok sa collusive, coercive, no? Tsaka mga fraudulent, no? At corrupt practices. Next slide. Ito, enumerate ko na lang kasi na-discuss ko na ito earlier. Submission of eligibility requirements containing false information or falsified documents. It's ground for blacklisting. Submission of bids that contain false information or falsified documents or the concealment of such information in the bids in order to influence the outcome of eligibility screening or any other stage of the public bidding. That is a ground for blacklisting. Refusal to clarify or validate in writing its bid during post-qualification within a period of 7 calendar days from receipt of the request for clarification. That is a ground for blacklisting. Why? Because supposedly during post-qualification, they should cooperate well with the back para matapos na yung, ma-declare na sila na LCRB if once kompleto na yung proof nila. No? So if they refuse, then that is a ground for blacklisting. May bid security pa na pwedeng makuha. That is if without justifiable reason. So any documented unsolicited attempt by a bidder to unduly influence the outcome of the bidding in his favor. Kinakausap niya yung ibang mga bidders, kinakausap niya yung mga back members at back secretariat kahit meron tayong no contact rule. So, allowing the use of one's name or using the name of another for purposes of public bidding, especially for licenses, no? May mga iba kasi na biglang naging negosyante na lang lately. Lalo na ngayon sa procurement ng mga, bakit biglang may negosyo na to? So, anong ginagamit nila for their SLCC? Kasi di ba may mga requirement tayo. Okay lang yung sa emergency, may mga skip tayo na documents. But for some contracts like infra, may mga requirement kasi tayo for the eligibility documents to make sure that they are reliable suppliers. Tapos, ginagamit na lang nila yung sa iba. Kasi nga wala pa silang masyadong experience. So, of course, also yung mga eligibility sa pick-up, yung mga ganon. So, we have to be vigilant on that. Kasi that's a ground for blacklisting. Pag hindi nyo na pansin yan, baka pati kayo, mademanda pa. So, withdrawal of a bid or refusal to accept an award or enter into contract without justifiable cause after he has been adjudged as having submitted the lowest calculated responsive bid for infra and goods and for the highest rated responsive bid for consultant. So, pag hindi ini-accept ang award or hindi siya maka-enter into contract dahil hindi siya mag-post ng performance security niya or hindi talaga siya magsiset kailan siya pupunta para pirmahan yung contract niya without justifiable cause, then that's a ground also for blacklisting. Then refusal or failure to post the required performance security within the prescribed time, as I mentioned, and all other acts that tend to defeat the purpose of the competitive bidding, such as habitually withdrawing from bidding or submitting late bids or patently insufficient bids for at least 3 times within a year except for valid reasons. I don't know if you have experience with the Bayanihan Fund lately. Ay, hindi pa. Kasi may mga emergency procurements tayo, no? At nilalax yung mga requirements. Yung iba talaga, medyo hindi pa sila masyadong sanay sa government procurement. They don't know even how to label their documents or put it in the right folder. Yun, isa yun sa mga pwedeng grounds natin. Pero pag paulit-ulit na, mali-mali, parang so that could be at least 3 times within a year. It could be, or insufficient yung bid nila. It could, bakit natin i-consider yan as a ground for blacklisting? Because it could signal, it could raise an alarm na baka may mga nangyayari sa likod, may mga collusion, no? Hindi lang siya simple na negligence. It could be an indicator that behind the back's back, behind the back's back, there is a collusion that is happening between the bidders or between bidder and other interested individual parties. So yun yung babantayan natin. Kasi anti-competitive siya, So, what are the sanctions for blacklisting during procurement stage? Of course, mapi-feature. During procurement stage, andyan pa yung bid security nila. So, mapo-forfeit yun. for first offense. For blacklisting, just like suspension, blacklisting for first offense could be for 1 year and second offense for 2 years. Then i-enforce din natin yung bid securing declaration if ever BSD yung ginagamit. So this is without prejudice to the imposition of additional administrative sanctions as the internal rules of the agency may provide and our further criminal prosecution. So remember ha, yung blacklisting, additional penalty lang to. Just like the suspension, additional penalty. Hindi pa dito nawawala yung mga imprisonment, yung mga civil liabilities at mga, ito administrative dito, administrative sanction. So civil, penal, and administrative, ito kasama to sa administrative sanctions. So yan yung ipo-forfeit natin. Kaya remember, when you extend, there will be time, no? May mga extension time nangyayari. If you extend the bidding, may maximum kasi, di ba, may mga siniset tayo sa calendar natin sa bidding procedure, sa stages. Minsan na-extend tayo. Make sure that their bid security, especially, di ba, parang dapat makaka-cover siya just in case may magaganap during end stage na yung mga award na, before na award, may mga violation siya na pwede i-blacklist, may mapo-forfeit tayo. Baka mawala na tayong mapo-forfeit kasi matagal na nag-i-expire. So, yan. So, next. So, what is the procedure, no, for blacklisting during procurement stage? So, who may initiate, sorry. Careful tayo. Who may initiate at who may initiate. So, who may initiate? Any bidder or prospective bidder. Siyempre, sila yung aggrieved eh. Diba? Sila yung feeling nila na lugi sila. Then, be careful with this. Duly authorized observer. If your observer can find something na pwedeng ma-blacklist. So, kunyari, si observer, nagsusigarilyo lang dun sa mailalim ng mangga, naririnig niya yung ibang bidders nag-uusap. So, pwede siyang mag-file na, mag-initiate ng action. Then, of course, you, the back. The back may also motu proprio, meaning and your by itself, at your own initiative, commence the proceeding upon prima facie, on the surface, determination that the contractor as a bidder or prospective bidder has committed any of the grounds for blacklisting during the competitive bidding stage. So, yun yung pwedeng mag-file na, mag-initiate ng action. At the option of the procuring entities, pwede talaga sila yung back, pwede talaga sila yung mag-initiate. Pwede yung observer at pwede yung prospective bidder. So, what will happen after the initiation of action? No? May complaint na action for blacklisting. So, the back shall notify the contractor, yung inireklamo, in writing upon verification of existence of ground. That first, that the complaint has been filed. May reklamo po sa inyo. That he has the opportunity to show cause, mag-explain po kayo kung tama ba, may ground, tama ba yung ground na ni-raise or hindi. That a hearing shall be conducted, kung magre-request po kayo ng hearing, that the consequence is to be suspended and blacklisted. Pag hindi po kayo mag-request ng hearing, hindi po kayo sasagot, kung itong complaint lang po sa inyo ang i-rely namin, baka po kayo masuspensa at ma-blacklist. So it is part of the due process, no? Na to give the contractor an opportunity to answer all the allegations against him or against her or against the company. So the contractor shall submit its written answer to back with documentary evidence and request for hearing if he so desires. Kasi naman, when it comes to administrative matters, the due process, the right to be heard is already deemed complied pag may chance kang mag-answer. It doesn't necessarily to be na physical hearing, na actual sila mag-appear. The fact that you are given the chance to answer, to submit your answer, that is already, the requirements for due process has already been met, no? So, no time extension shall be allowed. Unlike regular complaints, actions, sa court, pwede, ito, train itong mga lawyers dito eh. Yung motion to file for extension, to file pleadings. Bakit? Kasi most lawyers and most even prosecutors, they only get a copy of the complaint very close na to the deadline. So they have to read, no? They have to be given the chance to read the complaint against them. Is that dito, it's an administrative procedure. So, walang time extension for submission of answer. They just have to answer it there. And if mag-submit sila ng request for extension, that is already their answer. So, wala silang na-raise na defense. No, wala silang na-raise na defense para sa show cause order. So, at the option of the procuring entity, ito pwede. At the option ninyo as LGU, a reasonable fee may be required for initiating the blacklisting proceedings. So, meaning, if ito, yung ibang bidder or prospective bidder ang magreklamo or duly authorized observer, pwede kayong mag-set through a resolution nyo na initiating the blacklisting proceedings. Why? Diba? Bakit? What is it for? Because, of course, it's an additional job sa inyo, diba? Specific lang naman ano yung mga procurement stages. Pag meron kayong mga actions for blacklisting, ang tendency, it will require you to perform a specific task, special task, which could take you away from your work, so, or take so much of your time. So, pwede kayong mag-impose ng reasonable fee. It's not just the protest fee, no? Yung protest fee, pag yung prospective bidder supplier nagrereklamo ito naman, para sa blacklisting procedure na to. Kasi, if you will notice, a blacklisting procedure is separate, no? Is separate from the penal at civil. Ito administrative lang din. So, for this purpose, multiple violations in a procurement project as grounds for blacklisting shall be included in one project. Kahit ilan pa yung violation nila, isang complaint lang yan. Although it shall be considered as separate offense. Isang complaint lang ang isa-submit ng complainant. But once proven, it could be already considered as separate offenses. Iba-ibang penalty. Lalo na pag di na-absorb yung isang offense sa ibang offense. So, sample, sa isa, falsification siya. Sa isa naman, submission of bid siya. So, blacklisting procedure during procurement stage. If contractor does not submit an answer. Ito tayo pag after may nag-initiate ng action at nag-submit na ng show cause order, nag-forward na ng show cause order yung back to the contractor. Kasi ito, dadaan mo na to sa back basta procurement stage. Pag yung blacklisting procedure during procurement stage, dadaan pa yan sa back. So if ang contractor hindi siya nag-answer, anong mangyayari? Within calendar days from receipt of notification from back, the back shall recommend to the hope. Automatic yan. The suspension, automatic yung recommendation na hindi automatic yung suspension. Automatically, the back shall recommend to the hope the suspension of the contractor and the forfeiture of bid security. Okay? So, pag di siya nag-submit, automatic na lang gagawa yung back ng recommendation for the hope to suspend the contractor and forfeit the bid security. Wala nang chance yung contractor mag-argue at the level sa back. So, what will happen when it arrives to the hope's desk? So, dalawa lang yan. Within 15 calendar days from receipt of the back resolution recommending the suspension and forfeiture, the hope shall determine the existence of reasonable cause. Pag may reasonable cause, hope issues suspension order and forfeiture of bid security. If without reasonable cause, then he shall dismiss the case. This is a quasi-judicial function on the part of the hope. He can dismiss the case if walang reasonable cause. But for the back, it has no option but to recommend the suspension and forfeiture if there is no answer. Yung hope pa ang may determination, yung may discretion to determine whether or not a reasonable cause exists. Okay? So now, what if the contractor submits an answer? No, the hearing shall be if the contractor submits an answer within 5 calendar days from the receipt of his show cause order, no, asking him to submit his answer and also to whether or not he would request for hearing. If he submits an answer, titingnan din ng back. Ito, at the level of the back, if the contractor shall submit an answer, they will check if there's a request for hearing. If there's a request for hearing, the back shall conduct hearing and shall immediately set the date and time of hearing. Okay? Pag may request for hearing. Hindi pwede sabihin niya, you can request for hearing. Tapos pag may request for hearing, we denied. No, hindi niyo pwede i-deny yung request for hearing, pag mag-request. But if no, if walang request for hearing, then the BAC shall determine the existence of fault basing only on the complaint, the initial complaint, and the answer, and the documentary evidence and facts verified which is available to the BAC. Siyempre, yung mga documents na pinaghahawakan nyo. May basis pa rin naman sa determination of fault, existence of fault, even without hearing. Kasi meron kayong complaint, merong answer, merong documentary evidence and facts verified. Now, after that, once the BAC, after na ng hearing, or if without hearing, after na ng determination ng reasonable cause, the BAC shall recommend to the HOPE the suspension of the contractor and the forfeiture of bid security if they will find if they will find the existence of fault, no? So after that, the BAC shall recommend to the HOPE the suspension of the contractor and the forfeiture of bid security. So within 15 calendar days, ito lang talaga ang kasi di ba ang initiation sa protest is 3 and sa request for reconsideration is 3. Ito naman sa blacklisting is 5 days. But the rest, the BAC always has 7 calendar days. But in protest, the HOPE has 7 calendar days to decide. But in blacklisting, it requires 15 calendar days. So the HOPE determines existence of reasonable cause. So yun ha, the BAC shall determine existence of fault, probability that there is a fault or an infraction. But the HOPE shall determine the existence of reasonable cause na pwedeng administratively liable sila, yung contractor, which could be a ground for blacklisting. So if wala, dismiss the case. Hindi na i-blacklist. If meron, then HOPE shall issue a suspension order and forfeiture of bid security. Take note that in blacklisting, it has to go first through the suspension level and forfeiture. No? So, notice of decision. The HOPE shall furnish the suspended contractor a copy of the decision immediately after its promulgation. So the effect is masuspend yung contractor upon receipt of the notice of decision. Immediate na, hindi na kailangan ng 7 days. So the suspension shall remain in effect during the period of motion for reconsideration and appeal. Kahit may motion for reconsideration and appeal, if ever may appellate authority, sa inyo wala, hindi to applicable, yung suspension nito take effect na yan. Nag-determinate lang yan upon reversal of the decision of the HOPE or appellate authority or after na. No, pag na-terminate, pag wala na, tapos na yung period ng blacklisting at suspension. So if no motion for reconsideration or appeal is filed, the decision shall become final and executory after the lapse of 7 calendar days from the receipt of the notice of decision. So effective siya immediately. Pero kung walang motion for recon at blacklisting, final na siya. If no motion for reconsideration or appeal is filed, the decision shall become final and executory after the lapse of 7 calendar days from the receipt of the notice of decision, and the HOPE shall issue a blacklisting order. So to follow yung blacklisting order after ng suspension. So although nagte-take effect na yung, remember, a motion for recon is something that you will file to the person who made that decision or resolution. So you can file a motion for reconsideration if granted to the HOPE. No? Why not? But appeal, it is not an appeal. Appeal can only be available if there's an appellate authority. Take effect na yung suspension, pero wala pang blacklisting order kasi nag-file pa ng motion for recon. And the HOPE will decide again based on law, complaints, answer, and verified facts on the records. So, however, no, ito if my motion for reconsideration and appeal, ito na hindi na ako mag-ano sa. So when does the blacklisting order become final executory, no? So after na ma-receive ng contractor yung suspension order at forfeiture, he can file a motion for reconsideration before the blacklisting order will come out. And to whom will the contractor file it? It's to the HOPE. No? Bakit? Kasi decision niya ang i-reconsider. Hindi pwede mag-file ng motion for consideration on another forum. It's always where the body or the officer whose decision is being questioned, doon yung mga reconsideration na yan. So HOPE shall resolve the motion within 7 calendar days from the receipt and within 3 calendar days from receipt of the notice of decision. Decision does not 3 ano lang yan, yung filing ng MR 3 calendar days uli, ang Hope 7 calendar days. Pero what's the ground? Dapat merong newly discovered evidence at dapat the decision is pointed out, may ipo-point out sa decision na hindi nag-conform with the evidence of fact. Kasi dapat yung decision based on evidence and fact yan eh. Diba? Pag may mga makita din sa contractor na ay hindi based on evidence yan, wala namang sinasabing ganyan, bakit mo sasabihin na ganito? Kasi nga, di ba sa facts, may enumeration ng, may statement of facts, huwag mag-presume. Ito sasabihin ko ha, sa inyo dyan na Hope or Back, you don't assume facts even if you knew it personally. Kung ano lang ang nakalagay sa complaint, ano lang nakalagay sa position, yun lang yung pagbabasihan ng decision nyo at resolution. Do not assume facts which is not there in the complaint or protest or whatever pleading that is submitted to you. Okay, kahit alam mo pa yan personally kasi no, unless kayo yung motu proprio, kayo yung nag-initiate ng action, but it should also be included in the resolution. Okay? Hindi pwedeng i-assume lang. Tapos lalabas na lang yung fact na yan sa decision. Hindi pwede. So after the 3 calendar days, the Hope shall resolve the motion within 7 calendar days. Now, if there's an appeal, just in case there's an appeal, sa inyo wala to, pero sasabihin ko na din, yun lang din, titingnan lang if filed within the appellate authority within 7 calendar days from receipt of notice. If no, Hope issues blacklisting order. Ito yung applicable sa inyo kasi walang appellate authority. Ang Hope, pag na-final na, mag-issue na yun ng blacklisting order. Pag yes, applicable to appellate authority muna. So, it is the decision to suspend that becomes final and executory, which results in the issuance of blacklisting order. Conversely, the blacklisting order contains, among others, the sanctions imposed the hearing contractor. For example, yung ibang mga sanction pa, the disqualification, no? So, yun yung process natin sa blacklisting. You cannot have a the Hope cannot issue blacklisting order without going through all this. Ha? Wala yung suspension at forfeiture, yung process. Hindi pwedeng, may violation. Blacklist na yan. Hindi. Dadaan yan sa due process ng suspension, ng administrative procedure. So, blacklisting order, 1 year or 2 years, and just like suspension. So, knowledge check.
All right. So for this particular knowledge check, may I request all participants to type in their answers to our Zoom chat box because this knowledge check is extra special as we're going to give special token to the first participant who will going to answer our question correctly. Okay, so, and the question is, may a procuring entity conduct necessary modification of the posted blacklisting orders? Yes or no? Again, may a procuring entity conduct necessary modification of the posted blacklisting orders? Yes or no? Again, guys, you may type in your answer to our Zoom chat box. All right. So 77% po attorney ang sumagot ng yes, while 23% naman po ang sumagot ng no.
Yes. Actually, the answer there is yes. Pwede talaga mag-modification ng blacklisting order. It's allowed by law. Actually, blacklisting naman talaga, I didn't even see any provision under the law that requires you to go through all the blacklisting. Kailangan mo naging mandatory siya. Wala akong nakita na provision na sinasabi. Ang sinasabi is may mga you initiate for penalty, hindi yung blacklisting kasi it's just an administrative. There could be other sanctions available. So of course, you can make necessary modification of the posted blacklisting orders anytime, no? So may appeal. Yun siya, yes. Marami naman nakakakuha, no? Although it was not discussed. Siguro, so mga readings na lang siguro ninyo nakuha yan. It was not discussed.
Okay, attorney, our knowledge check winner for today, upon verification and validation po of our technical team, we would like to congratulate Josie May Yu from LGU Liloy. So again si Miss LGU, again si Josie May Yu po ang nakasagot ng tama, though he's not really the first one to type in the correct answer. Yung mga nauna po ay nanalo na po kasi sa ating mga other activities. So again, we want to remind everyone that you can only win one time for the whole duration of our training. Again, ma'am, please continue po.
A moment lang, mag-restroom break lang muna ako ha. 1 or 2 minutes kasi last na din natin to yung ground for blacklisting during contract implementation stage. Can I excuse myself?
Yes po, ma'am. Sige po.
Sige. So yeah, I'm back. Pasensya na. May inom din kasi ako inom ng tubig kasi nga pag nagsasalita ka, medyo nauuhaw ka. Anyway, your incentive, no? Maganda yun kasi at least na may incentive yung mga awake. Sa mga tulog naman, may incentive din sila. At least nakakapahinga yung mata nila at isipan nila. Pero sa mga gising, yun yung incentive nyo. Congratulations. So let's proceed with the blacklisting during contract implementation stage. So kanina, when we refer to the, we still call them contractor, but actually they are considered, during procurement stage, they are considered as prospective suppliers or contractors or manufacturers, no? Ang ini-expect dyan, yung mga violations nila andun during the procurement stage at nakita ka agad. However, for grounds for blacklisting during contract implementation stage, pwedeng nagka-cover siya ng mga offenses committed during the contract implementation stage, but it could also go back to their offenses committed but that was later on discovered during bidding process. So, among those grounds for blacklisting during contract implementation stage, meaning tapos na, may NTP na, pwedeng nagsimula na or wala pa, or may award na. So failure of the contractor due solely to his fault or negligence to mobilize and start work or performance within the specified period in the notice to proceed. So yan. Sa notice to proceed pa lang, hindi na siya kaagad ka nakastart. Tapos with solely to his fault or negligence. May mali siya. Hindi pala siya ready after niya na yung NTP. So, nakuha pa ng advance. So, failure by the contractor to fully and faithfully comply with its contractual obligations without valid cause. So, dapat may valid cause kung delay sila. Or failure by the contractor to comply with any written lawful instruction of the procuring entity or its representatives pursuant to the implementation of the contract. So, there are instances na minsan nadidelay yung mga contractor. Because, for example, especially if it's rebel-infested areas, sinusunog yung mga heavy equipments or may mga threats against the lives of the workers, it can be considered as a valid cause for the delay. And that failure of the contractor to immediately start the project and comply with its contractual obligation is justified. No? So, another thing is, for example, kailangan meron ding requirement ng agreement ng procuring entity and the contractor that the procuring entity will provide this and that, and the contractor will provide this and that. Tapos na-comply na ng procuring entity ang part niya, tapos yung contractor without any written lawful instruction, without any justifiable cause, hindi niya ma-comply yung instruction sa kanya ng procuring entity. So, another would be assignment as subcontracting of the contractor, ito, or any part thereof or substitution of key personnel named in the proposal without prior written notice of the PE. So, ito, di ba sa infra, nagsasubmit sila ng sino ang mga tao, sino ang mga project engineers, sino yung mga safety engineers na involved. Tapos, yan, ganda-ganda ng license dyan, mga experience. Tapos, during actual, walang prior written approval by DPA kung may mga pinalitan sila. Either the contractor is either it's a infra or a consultancy project. Kung any changes in the key personnel or substitution or any subcontracting on some parts of the contract is required, then prior written notice of the approval, prior written approval by the procuring entity is necessary. If gumagawa sila dyan ng hindi nila pinapaalam sa procuring entity, most of the procuring entity would say, we could just turn a blind eye. But if anything happens, for example, the delay is caused by the subcontractor or by the key personnel na hindi naman pala as competent as those that were promised in their bid proposal, then that can be a ground for blacklisting on the part of the contractor. Pwede silang ma-blacklist dyan kasi hindi naman talaga inallow in the first place ng procuring entity na i-subcontract nila. Minsan kasi sabi natin, I know that's a lot of, it's happening always yung subcontracting, no? Hindi pinapaalam. And even if the LGUs are aware of that, they turn a blind eye because what's important for them is ma-finish yung contract. It's okay. Sa akin nga, sabi ko, minsan, naintindihan ko din yung mga LGUs kasi kung sistriktuhin nila yan, baka wala na talagang mag-bid sa kanila, especially those far-flung municipalities. I know the law requires too much from us and the realities on the ground, yung Diyos ko, kulang na lang, makiusap na lang sila ng mga bidders kasi walang pupunta doon kasi middle ng mahirap maghanap minsan. Lagi tayong napi-failure. Kaya minsan pinagpasensyaan natin na yun ng mga lapses ng mga contractors at bidders. Tinatanggap na lang natin, konti lang yan, delay o konti lang yan. Pero pag may problem na, it could be a ground na din na i-raise ninyo. So for the procurement of infrastructure projects or consultancy contracts, among the lawful instructions that may be included, yung sa number 2, yung employment of competent technical personnel. Hindi pala, competent engineers, work supervisors. Tapos pagpunta doon, nag-check yung project monitoring committee ng LGU, laging walang tao, di ba? Provision of warning signs or barricades na yung mga tao sa yung mga constituents ni Mayor biglang nahuhulog sa mga constructions. Yung daan na biglang walang mga barikada. So, dapat kasama yon kasi even if wala with approved plans and specifications, dapat kasama yon, tinitingnan, ma-require. Yung mga stockpiling in proper places of all materials, baka mamaya nakaharang na sa iba. So, yung stockpiling din per instruction ng LGU sa inyo na part ng procuring entity na may proper places sila na hindi naman maapektuhan yung community. Also, of course, deployment of committed equipment, facilities, support staff, and manpower. We know for a fact that a lot of contractors are handling projects 2 or 3 at 4 at a time together. Diba? Sabay-sabay yung mga projects nila. So, their equipments from one project site to another, ganun yung usual. Minsan, may delay dito, kaya hindi makastart doon kasi hindi pa tapos gamitin dito. So, it could be a ground for blacklisting if parang, depende talaga kung sistriktuhin nyo, no? Pero minsan kasi tumatakbo din yung oras at naabutan tayo, lalo na coming na yung mga election ban. Be wary of that. Bantayan nyo yan. Baka dahil sa kapalpakan ng contractor, hindi man lang makastart. So, renewal of the effectivity dates of the performance security, ito. Request sa contractor ng extension ng delivery or performance niya, yung end. Tapos, yung performance security pala, hindi din niya accordingly in-extend. So, if ever talaga, hindi talaga niya ma-meet yung requirements ng contract, yung obligation niya under the contract, baka wala tayong habulin na performance security. So, kahit wala kayong mahabol na performance security kasi magulang na tao yung si contractor, it's a ground for blacklisting for him. Kasi pag nag-extend siya ng obligation, performance ng obligation, dapat in-extend niya din yung performance security niya para may mahabol tayo, no? So, dapat i-renew niya yun kung sige pa yung kontrata, ongoing pa yung project. Another ground would be the for procurement of goods and satisfactory progress in the delivery of the goods by the manufacturer, supplier, or distributor arising from his fault or negligence or unsatisfactory or inferior quality of goods, no? As may be provided in the contract. So, ano nga ba yung sa goods? Usually kasi sa goods, off the shelf or pinagawa, one time kasi minsan yung ma-delivery. Unless sobrang dami, may inalagay kayo na ganito yung i-deliver nyo this period, this period, this period. While the period of delivery, while the time for delivery has not yet arrived, they can deliver and withdraw some of their items, no? Anytime. Basta ang importante at the time, yung deadline talaga ng delivery, satisfactory yung quality ng goods na i-deliver sa inyo based sa specs nyo. Based sa specs nyo. Yun lang talaga. I-determine nyo yan kung may delay siya or may hindi niya na-meet yung performance obligation niya pag at the time of the deadline, pasensya, Bisaya po ako. At the time of the, medyo matigas talaga. Medyo time of the deadline of the delivery will be the period na dapat na-meet na niya yung quality din. So, kung, for example, nag-deliver siya, ay, kulang pala to, ay, manipis pala to yung papel na ginagamit, say, papalitan namin, okay lang yan, wala pang penalty yan ha. May penalty, magsa-start na lang. Pag, for example, dineliver niya, Monday, ngayong Monday yung delivery niya, tapos, delivery niya sa Monday, defective. Nag-deliver siya next week na, o yun, yung 1 week na yun, may penalty na yun. At pwede na yung grounds for blacklisting. Pero depende talaga yan. Kasi kung yun mastrictuhin masyado, i-allow nyo na lang yung extension. Kasi allowed naman talaga tayo mag-extend, di ba? Ako nga sinasabi ko talaga, if you cannot, the contractors, if you na-anticipate nyo na magkakaroon kayo ng delay, mag-submit na kayo ng request for extension before pa mag-expire yung contract. So defective design, how about for the consultant? For the procurement of consulting services, poor performance by the consultant of his services arising from his fault or negligence is also a ground for blacklisting. So any example about this, of this are, for example, defective design resulting in substantial corrective works in design and or construction. Di maganda design niya, nagko-correct tuloy, so extra expense for the government. So failure to deliver critical outputs due to consultant's fault or negligence. Si consultant, di natin control ang time niya kasi hindi siya empleyado ha. Remember, consultants don't have government employer-employee relationship with us. You can require the consultants to report on certain days and time for updating of the output, no? Pwede niyang yung deliverable niya. For us to make sure na within siya sa track ng project. But if he cannot deliver due to his own fault or negligence, then that is a ground for blacklisting. Hindi na nga nagpapakita, wala pang na-deliver. Tayo naman, bayad tayo ng bayad. Walang naipakita, walang na-deliver. So although they are free with their time, it doesn't mean we cannot ask for regular updates, and it doesn't mean na pag nag-fail sila mag-deliver ng critical outputs, we cannot impose sanctions. So now, and another also specifying, for example, yung mga design and build na mga projects, specifying materials which are inappropriate, substandard, or way above acceptable, or way below acceptable standards. So yun din titingnan natin, baka mamaya hindi bagay. Baka naman mga ano na lang yan, 4-story building, tapos ang liliit ng mga kabilya. Kabilya ba yung tawag sa inyo sa Tagalog? Sa amin sa Bisaya, kabilya ang tawag dyan. Yung mga iron. Hindi ko alam anong English na, hindi kasi ako ano talaga. So yung mga, yung materials, dapat appropriate siya at hindi siya substandard. Okay? Any of the following acts as the contractor ISB daw. So any of the following acts by the constructor din, yung mga sa infra naman shall be construed as poor performance. Yung mga negative slippage, no? A negative slippage of 15% and above within the critical path of the project due entirely to default or negligence of the contractor and quality of materials and workmanship not complying with the approved specifications arising from the contractor's fault or negligence. Ang ano kasi natin dyan, di ba, may Gantt chart naman tayo sa infra. Yung infra kasi, ang payment dyan, staggered yan, di ba, based on the actual accomplishment. So based din sa Gantt chart at sa actual accomplishment, yun natin monitor yung slippage nila. Yun lang yung problem. Kasi, kaya nga, required talaga, for LGUs, you have to have a team or a committee na mag-check ng project monitoring. At least you will know the status. Hindi yung bigla, wala na. Hindi pala natapos. At nakikita nyo na yan eh. If it's a Gantt chart, hindi ba siya nakafollow? Paunti-unti na yung slippage. Nag-accumulate kasi yan eh. Parang ngayon, 3% slippage pa lang. Next, 2%, may additional na 2, 5% na. Nagba-backtrack eh. So, yun yung tinitingnan nyo. For the procurement of infrastructure projects, yun considered as poor performance by the contractor or unsatisfactory quality in our progress work. No? So, for example, may mga daan kayo, hindi na-cure yung semento ng daan nyo. Butas, pangit ng texture sa top. So, yun yung quality din ng workmanship na not complying with the approved specifications. Ipatrabaho nyo uli yan kasi meron namang retention money nakaka-cover dyan. Kung hindi nila tatrabahuin, ipatrabaho nyo sa iba pero i-charge sa kanila. Yun yung mangyayari. Kasi meron din tayong constructor's performance evaluation system, no? So, i-utilize natin yan, pati yung performance monitoring system. So, yan. Willful or deliberate abandonment or non-performance of the project or contract by the contractor resulting to substantial breach of without lawful and or just cause. Ito nangyayari to pag medyo yung abandonment or non-performance of project. Kasi yung iba kasing contractor, medyo lugi-lugi na. May mga delay na sila sa ibang project nila, hindi na sila makastart sa inyo, hindi na nila matapos. One time, I attended a PIC activity. Sabi nga, ma'am, luging-lugi na ako. Pag tinapos ko pa yan, bankrupt na ako. Pakulong niyo na lang ako. Example, nag-usap lang kami nun kasi nilapitan niya ako personal. Bakit nalulugi ng ganun? Kasi nga, marami na silang mga backtrack. And of course, corruption. Corruption is really one of the factors bakit maraming abandoned projects. Kasi nga, yung SOP, mas pinaprioritize. Yung SOP, alam niyo yun yung SOP. Hindi, wala yan sa definition of terms natin ha. Kasi supposedly ideal yung dinidiscuss natin eh. But that's the reality, no? Sobrang priority yung mabigyan yung mga daming mabigyan ng SOP, naubos na yung budget. So, pati yung ibang project nagdo-domino effect yung failure ng mga projects ng certain contractor. And this, then, ito din nagpa-prompt sa akin for you to look back with your, yung sa NFCC, sa net financial contracting capacity. May maraming mga contractors na over-leverage na sila. Kumbaga, sabi pa ni Frank Sinatra, I bit more than I could chew. Diba? More than they could chew. They bit more than they could chew. Sa my way yun, na kanta. So, over-leverage na sila. Hindi na kaya ng capacity nila para lang makalusot yung NFCC na tinatago nila yung ibang mga contracts nila. So, paano natin mahabol yun? It pays to be friendly also with other government agency. And of course, try to check with DPWH because DPWH has a lot of projects, no, with different contractors. So they are the ones who has more knowledge kung sino yung mga parang marami ng projects. So i-check nyo na yan. Tapos tatawagan nyo yung mga previous nila na agencies na meron silang project, kung natapos ba talaga, wala bang reklamo. Because if meron silang problem doon, most probably, may mga na din sila, history na sila sa ibang agency. So, it's due diligence. it's only during preliminary examination of bids, yung sa pass-fail, na pwede tayong sabihin natin, we only rely on the paper. But during POSPA, there's nothing, as long as pasok kayo sa period, there's nothing that prescribes, that stops the back to check on the representations made by the prospective bidder. Kasi nga, dito yan sa during contract implementation stage lalabas. Para lang yung, alam niyo yung sa annulment, yung psychological incapacity? Para lang yung psychological incapacity, yung defect, andyan na yan, nakatago lang hidden before marriage, before the contract was entered. Pero lumalabas during the contract implementation stage, during marriage. So same lang yan. So dapat due diligence before the contract is entered. So another also, in case it is determined prima facie that the contractor has engaged, ito yung before or during implementation of the contract in unlawful deeds and behaviors relative to contract acquisition and implementation. So during the contract implementation na, may mga nakitang prima facie evident determination that the contract has engaged in unlawful deeds and behaviors relative to the contract acquisition, meaning yung sa bidding stage and implementation. So any unlawful deeds as mentioned earlier, pwedeng babalik yun sa kanya, magbubumirang pa rin. Hindi siya makakalusot just because he has already been awarded with the contract if later on it can be found. So pwede pa rin iba-blacklist siya. So sanctions. Of course, we will discuss later what would be the effect of the project. But of course, we'll go first to the sanction. Sanctions for blacklisting during contract implementation stage, of course, ipo-forfeit. Tapos na yung bid security. Ito na naman performance security. No, yan yung ipo-forfeit, yung performance security. The first offense also could be blacklisting for 1 year. And the second offense, blacklisting for 2 years without prejudice to other additional administrative sanctions. No? So, yan. So, blacklisting procedure during contract implementation stage, of course, sabi natin yung notice of blacklisting, yung show cause, at yung decision. So, upon termination of the contract due to default or unlawful order of the contract, the hope shall issue within 7 calendar days blacklisting order. Where contract termination is no longer possible, but the contractor committed acts or causes which may constitute grounds for blacklisting, the implementation unit within 7 calendar days after the lapse of the project duration shall cause the execution of verified report with relevant evidence attached, no, subject to the following procedure. So yan talaga, notice of blacklisting. May nagreklamo. Ito na, may prima facie either motu proprio or may reklamo. Tapos show cause order for them to answer and the decision. So medyo meron tayong required na verified report after the contract, if the contract termination is no longer possible. So, yung notice of blacklisting upon recommendation of the implementing unit yan. Kasi minsan, di na natin yan nakikita back. If you notice back, most sa inyo dito back, no? Dito. If you notice, for blacklisting procedure during contract implementation stage, labas na kayo. It's already at the hands of the implementing unit through the hope. Okay? Yan na. Tapos yung sino yung i-assign niya na mag-project monitoring. Ang meron lang involvement yung back for blacklisting is yung during procurement stage. But during contract implementation stage, wala na. Yung okay na ang back dyan. So notice of blacklisting upon recommendation by the implementing unit, the hope shall initiate the blacklisting procedure by a written notice to the contractor with the following information. Statement of the acts which constitute the grounds for blacklisting, yung mga na-mention ko earlier na mga possible nilang nagawa. An instruction of the contractor to show cause as to why it should not be blacklisted. Sabihin nyo bakit hindi kayo dapat i-blacklist. Yun yung show cause. Then, of course, the special instructions of the procuring entity, if any. Kung meron kayong mga special instructions earlier, di ba, na yung mga barricades, yung mga signs na hindi na-comply. So notice of blacklisting shall be accompanied by the verified report. And who will make the verified report? The one who is monitoring the project, no? Sila yung inassign ng implementing by the hope. So then what will be the content of the show cause? What will happen after the notice of blacklisting? Then the show cause order will follow. Within a period of 7 calendar days from receipt of the notice of blacklisting, the contractor shall submit to the procuring entity a verified position paper. Again, verified. It must be notarized in an affidavit form stating why it should not be blacklisted. It's not a letter, ha? It's not a letter, but a verified position paper stating why it should not be blacklisted. So, meaning since it is a verified position paper, the contractor should be able to answer the facts, the allegations against him. And if in asking why she should not be blacklisted, he should cite the laws as his defense. Bakit hindi siya pwede ma-blacklist on those grounds? So if the contractor fails to show cause after the lapse of 7 periods, pag hindi niya na-prove na show yung cause why he should not be blacklisted with or without an answer, either hindi siya nag-answer, hindi siya nagsubmit ng verified position paper, or nagsubmit siya ng verified position paper but it did not show cause why he should not be blacklisted, then after the lapse of 7 days, the Hope shall issue a blacklisting order. Okay? So, the decision within a non-extendable period of 10 calendar days from receipt of the verified position, the Hope shall decide whether or not to blacklist the contractor. So 10 days, 7 days, dapat yung ibinigay ng kay contractor to explain himself. Within 10 calendar days naman, binigay ka na time period kay Hope to decide if ma-issue ba ang blacklisting order o hindi. Okay? It shall serve a written notice to the contractor of his decision, which shall become final executory after the lapse of 7 calendar days from the receipt of the notice of decision. So, be careful with the, sa atin, wala nang, more than 7 calendar days pa rin yung blacklisting order, notice of blacklisting, notice of blacklisting requiring him to show cause, the contractor. The contractor shall be given 7 calendar days again, but the Hope shall be given 10 calendar days to decide on the matter. No, if whether i-issue ba yung blacklisting order o hindi. Pero, remember, the blacklisting order shall follow the, yung usual talaga, it follows the suspension order. But in contract implementation stage, hindi na kasi siya daraan sa back. Wala na. So, diretso na talaga siya blacklisting. Wala nang suspension order. So, when does blacklisting order become final executory? After the lapse of 7 days from the issuance of the notice from the Hope. So, if the bidder did not file a motion for reconsideration sa decision ng Hope, 7 calendar days. If the bidder will decide to file a motion for reconsideration, then after din ng decision ng Hope, saka magka-count yung 7 calendar days. Depended, as I mentioned earlier, it depende kung may appeal or wala. Sa case ng LGU, since you're all LGUs here, walang appellate authority after ng Hope. So they have to go to the court for anong posibleng ground nila sa court. Pwede na sila mag-petition for certiorari. Grave abuse of discretion amounting to lack or excess of jurisdiction. It's actually Rule 63 of the revised rules of court. It's a special provision. Hindi siya appeal. It's more of a certiorari. Walang jurisdiction. Lack of jurisdiction siya. Grave abuse of discretion amounting to lack or excess of jurisdiction. So we go to, before issuance of blacklisting order, ano ang status ng blacklisted person or entity? The hearing contractor may participate in the procurement of any government project. Pwede pa siyang makisali sa ibang government project except in the agency where he is suspended. Now, in general, we're talking now about blacklisted person, whether or not he is blacklisted during procurement stage or during contract implementation stage. What will happen to him? So, before issuance of blacklisting order, suspended pa lang siya. So, hindi siya pwedeng mag-participate sa procuring entity na mga procurement activities, but he can still participate in the procurement activities of other government agencies. However, after the issuance of blacklisting order, titingnan din natin kung yung blacklisting order niya issued before notice of award. If the blacklisted person or entity shall not be qualified, if it is issued, wait. Naglobat yata ako. Okay. If the blacklisting order was issued before notice of award, then the blacklisted person or entity shall not be qualified for award. Meaning ito, blacklisting order during procurement stage ito ha. So, during procurement stage, then he shall not be awarded na. Hindi na siya ma-qualify for award or such project or contract that be awarded to another bidder. But if the blacklisting order is issued after the notice of award, meaning during contract implementation stage na, then the awarded project or contractor shall not be prejudiced by the said order provided that the said offense is or not connected with the awarded project or contract. Kasi there are times na ang isang contractor, marami siyang project sa isang agency. So, although may blacklisted order siya during contract implementation stage, if hindi siya mapiprejudice, pwede pa rin niyang ituloy yung contract niya, provided hindi yun yung same project or contract awarded where na-commit niya yung offense niya. Yun lang siya. Okay? So, first niya i-determine talaga is may na-issue na ba na blacklisting order o wala. Saka nyo ma-decide kung pwede ba siya sa procuring entity or sa other government agencies. Then second nyo i-decide if may blacklisting order na issue before ba siya sa issuance of NOAA or after the issuance of the notice of award. So, application of penalty here. Because minsan kasi, di ba, lalo na pag si contractor, daming blacklisting action initiated against him na kasi marami siyang nabiktima na LGU. Si LGU A, B at C at T parehong nabiktima sa delay niya kasi nga na over-leverage siya, hindi na niya kayang habulin lahat ng contract niya. So, the remaining period, pag meron siyang existing, nauna yung si LGUA, nag-blacklist sa kanya. Tapos, blacklist din siya ni LGUB. So, the remaining period of previous, in case the penalty of blacklisting for 2 years is imposed during the pendency of a previous blacklisting order, the latter shall be deemed terminated and subsume siya of the new 2-year blacklisting order. No? So, pag first time pa lang niya or second time pa lang niya nagawa, yung existing niya na blacklisting order, hindi pa man matapos yung 2 years, papasok na yung iba. So si A, 2 years, yung blacklisting order na niya sa contractor. Before pa natapos yung 1 year, lumabas yung blacklisting order na kasi nga, di ba, minsan nakakakuha pa rin sila ng contract before lumabas yung blacklisting order. So, na-blacklisted na naman siya during contract implementation stage sa iba na LGU. So, yun, papasok na lang yun. Ma-subsume na siya. Pag first or second offender lang siya. Pag third offender na siya, the penalty shall be applicable for 2 years talaga. Pag third time, fourth time niya yan, lahat ng 2 years, isi-serve na niya. Hindi na pwedeng ma-subsume lang. Okay? Individual every 2 years, yung lahat ng 2 years, isi-serve na yan ng contractor. So, kung may 5 LGU siyang nabiktima, 10 years siya na mabablacklist. Kasi siya, I have to move around ha kasi medyo masakit din sa likod. So, yes. Ganun yung mangyayari sa penalty on blacklisting. Of course, please don't forget, blacklisting is just an administrative penalty. Marami pa tong kasabay. Maybe by this time, nakulong na si contractor or na-forfeit na yung ibang mga assets niya. So, marami pa iba. So, this is the next slide. Shows to you the blacklisting order form and provided through GPPB Circular Number 03/2020. Pwede nyo din pong i-click tong link na to and should not be modified kasi fixed po yan ng GPPB. Kasi baka, di ba, huwag nyo pong i-modify yan na. So, i-click nyo lang po yung link na yan. Yan na po yung pag may blacklist kayo. Okay? After the suspension order, pa-follow nyo na yung blacklisting procedures niyo. So, the blacklisting order shall be duly signed by the appellate authority, and contain the following. Ito yung mga required na isama dapat sa blacklisting order. So, name of the project, contract, complete registered business name. Kasi kailangan yan, pati yung field registration number, kailangan yan para sa dun sa online portal. Para yung ibang agencies na nag-check sa mga prospective bidders nila, hindi mabiktima kasi kompleto yung information. Pati yung sino yung authorized managing officer, yung business name nila, madaling mahanap eh. So, let's go to the knowledge check.
All right, at this juncture. Okay. At this juncture po, we're going to have our last knowledge check for this session. So our question po is, when does blacklisting order become final and executory? A, if the bidder did not file MR or the decision to suspend, said decision becomes the final and executory after lapse of 7 days counted from receipt of the notice of decision. B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from receipt of the resolution on the motion for reconsideration. C, if a protest was filed and the same was denied, the decision becomes final and executory upon receipt by the agency and person or entity concerned of the decision on the protest. Or D, all of the above. Again, when does blacklisting order become final and executory? A, if the bidder did not file a MR on the decision to suspend, said decision becomes final and executory after the lapse of 7 days counted from receipt of the notice of the decision. B, if the bidder did not file a protest after his MR has been denied, the decision becomes final and executory after the lapse of 7 days counted from the receipt of the resolution on the motion of recon. C, if the protest was filed and the same was denied, the decision becomes final and executory upon receipt of the agency of persons/entity concerned of the decision of the protest. Or letter D, all of the above. Again, you may select your answer to our Zoom polling feature in 5, 4, 3, 2, and 1. There we have it po, attorney. 88% po ang sumagot ng letter D, all of the above, while there is 7% po na sumagot ng letter A, same with 2% po ang B and C. Attorney, ano po ba ang tamang sagot para sa ating huling knowledge check?
Actually, it's also 88% were correct. But I would want to give benefit of the doubt kasi medyo baka nakakalito din. Kasi on the slide, paki-correct na lang siguro to. On the slide kasi, it used if the bidder, number 2, if the bidder did not file an appeal after his MR has been denied, or number 3, if an appeal was filed, the same was denied. Iyon yung nasa slide kanina. Kasi dito ang ginamit protest, parang bumalik tayo sa protest. Kaya I understand some of you were confused sa procedure. Oo, siguro i-correct na lang din ito. Hindi ko din yan napansin last time. So itong 2 and 3, itong 1, obvious naman yan. Pag walang MR, after ng decision to suspend, then maglalapse na yan. Yung blacklist order will follow na, di ba? 7% got it right. But because of the B and C, na instead of using the word appeal, protest yung ginamit, kaya yung iba nalito, hindi na nila na all of the above yun. So, it's actually a given. But for the 88, we were able to just parang nakikita lang, parang mali, lang siguro, hindi naman talaga yan yung proper word, pero ito talaga. So, congratulations for getting it. Yan, letter D, all of the above.
Okay. I think, ma'am, that is also the end of your discussion.
Yes, that's the end of my discussion. And I think there's an open forum. We still have 20 minutes.
Yes po, ma'am. But before that, allow me to thank you po for your wonderful and fruitful discussion po for the blacklisting guidelines. So at this point po muna, ma'am, we will be having a short break lang po muna, 5 minutes short break. So please be back after 5 minutes. Thank you. All right. So what you have just watched is the step-by-step procedure or instruction on how you will evaluate our resource speaker. Again, may I just remind all participants that you have to accomplish the said evaluation for you to have your certificate of completion. Okay, so let's now proceed to the open forum. At this point, we will be having the open forum. Our technical team has gathered your questions in the Zoom chat box and Facebook Live comment section. Now, may we ask our technical team to please flash the questions, please. Oh, by the way, we only have two questions, attorney. Pala. For protest mechanisms and remedies, considering the limitation in mobility, we have the MECQs, ECQs. What if the supplier that best fit the need of the procuring entity is a relative of the back member?
Okay. Ah, considering the limitations in mobility we have in the secure ECQ, kasi po hindi na bago yun yung limitations with the relative. Not only the limitations set forth by RA 9184, but even the limitations set forth by RA 6713 when it comes to government transactions. So the MECQ or ECQ, no matter how, even if it puts us into some difficulties, will not be our excuse, no, para yung relative. Tsaka eto lang, how do you know what's the best, what if the supplier is that best fit the need of the P? How would you know that siya yung best fit unless nakita nyo yung iba, di ba? Unless alam nyo na kung anong offer nila. So, yun lang ang ko. It is not an excuse because it's not only RA 984 that requires disclosure of relationships, but even RA 6713 or your code of conduct of public officers and employees. Yeah. So yun. The GPPB cannot make an exception na sabihin na ay hindi na pwede nang wala yan.
Okay po. So for our next question, attorney, blacklisting guidelines naman po ito. Katanungan po, maaari po bang ma-blacklist ang bidder na dati nang nagsagawa ng project subalit hindi naman po tinapos ang napagkasunduan? Maaari po ba silang makasali sa PhilJeps? Maybe referring to procurement through AMP.
Well, the idea dyan is abandonment of projects. It can be a ground for blacklisting, no? Kasi it's a violation of the contract. The contract has to be delivered. Kasi meron kasi yan sa contract eh. Principles sa contract. May principles kasi yung contracts and obligations, no? And that is the performance is one of the major obligation of the other party. And the other party's obligation is to pay. That is the government's obligation. So, kung may ina-abandon nila dati, and that could already be a ground for their blacklisting. And if they are blacklisted, hindi din sila makaano sa PhilJeps nila. For now, kahit may PhilJeps sila dati, maka-apektar yan sa status nila kasi they cannot depende sa period of time ng blacklisting order nila, they cannot transact with any government in the meantime. So, yun.
So, yan lang
Yes,
po ang
we should
ating...
initiate. Uy, mali. Konti lang questions nila.
Yes po, we only have 2 questions po for our open forum po. Yes, and that concludes po the open forum. If you have more questions, you may still ask them out even after this webinar by visiting slido.com. All you have to do is to just type in the event code #governmentprocurementph, to which the GPPB TSO will answer through an issuance or through a FAQs. Again, with that, we would like to thank our research speaker, Attorney Nogra, for graciously accepting our invitation to be part of this online training. Again po.
Can I also, thank, kasi binasa ko kasi yung mga chat. Ay, nadali. Parang nawala ba ako?
Nawala lang po yung camera po ninyo, ma'am.
Dali ha, oo. Dali. O yan.
Yes, ma'am.
Okay. Yun, kasi binasa ko yung mga chat. Marami palang taga Region 7 na nagjo-join. So, thank you, attorney. Ay, alam nyo, yan yung talaga yung pinakamasarap na feeling yung pasalamat sa amin during actual lectures. And I kind of missed that considering with this setup Zoom. And so I was very happy when I read your messages, and hopefully may natutunan kayo, yun lang. Thank you.
Yes, thank you po. Maraming salamat po, attorney.
Okay.
Okay, and for our winners po, please check your message or emails po. Our event secretary will contact you on how you can claim your tokens. Again, let me provide you synthesis of our today's activity. For today's activity, we have an in-depth discussion regarding protest mechanism and remedies, where we have learned the grounds and remedies of offenses committed in relation to the conduct and or participation to procurement activities, and understand the procedures on and considerations of how to resolve a request for reconsideration and or how to request for reconsideration. We also have to understand the procedure on imposing administrative sanctions in the form of blacklisting to bidders who committed any of the violations during the competitive bidding or contract implementation stage, and gain substantial knowledge on the responsibilities of the back secretariat, observers, bidders, and the end users or implementing units relative to the issuance and posting of the blacklisting order. Again, our today's session is led by Attorney Isafiel Nogra. So thank you so much po ulit for accommodating us. So before we end our today's session, allow me to make some few final reminders. Again, we would like to remind our participants to please register to the online training management system of the GPPB TSO, and participants' daily attendance sheet through Google Forms by visiting the link shared to you by our event secretariat in Zoom chat box. Rest assured that all the information gathered for this online training shall be treated with utmost confidentiality consistent to the provision of Data Privacy Act. Again, we would like to thank all NGUs for attending and participating in our fourth batch of the MLGO online training on RA 9184. I know that you have a great learning experience in the 5-day session in the procurement laws, rules, and regulations, though I think 5 days not really enough to discuss everything about RA 9184. As you go back to your respective office po, we hope that you may share to your co-workers and apply what you have learned from this training to help your office manage your procurement activities. This time po, mas well-versed na po tayo ngayon on the rules. To our Facebook Live viewers po, to all our Facebook Live viewers na sumubaybay from first day until today ng batch 4, maraming salamat din po. We also would like to acknowledge the efforts of our GPPB trainers to Ma'am Leslie, Director Laceras, Engineer Orsal, Mr. Aba, and to Attorney Isa, who have shared not just their knowledge but also their experiences in government procurement. Maraming salamat po for being our partners in capacitating our procurement practitioners. Please allow me to take this opportunity to also ask everyone to invite and inform your friends from other LGUs who have yet to participate in our trainings for MLGU, that we still have six more batches where they can register and participate. For our FB viewers who have yet to register, we pin a comment on the comment section on how you can register, or just simply visit our Facebook page, #GovernmentProcurementPH po. Before saying goodbye, may I request everyone again to please open their cameras for the last time for our group photo opportunity. Okay, for today po, we're going to have 3 shots. So, please smile po for the last time. Ayan. For the first shot po, 3, 2, 1. Ayan. Second shot po natin, 3, 2, 1. And for the third and last shot po natin, 3, 2, and 1. All right, that's it. That concludes the 5th and last day of the online training for the municipal local government units on Republic Act 9184 and its 2016 revised implementing rules and regulations for Batch 4. Again, in behalf of the Capacity Development Division and GPPBTSO, thank you for your active participation for our Batch 4. This has been your facilitator, Marky Duetes. Mabuhay and stay safe. Maraming salamat po.